petition or what? Orders writ petition of which year? 23. What is the urgency? (23) matter. Okay. Yes. Yes. 2nd of April. On a request made on behalf of the APDCL, matter is adjourned to be listed on 2/4. Yes. Okay. Revenue Department. Item number 10 is seeking adjournment. Okay. On a request made on behalf of Sri FZ Mazumdar, Learned Counsel, who is stated to be unwell, matter is adjourned to be listed on we'll have it on 28, 20. Not 28 is okay for you? 20? Yes. Or we'll have it on 18th. On 1st of April. 1/4. (18). Yes. Yeah, for the petitioner. 23 matter, forest matter. What is it? What is the matter about, madam? Any forest department counsel? No. You have taken the consent? Yes, Mr. No, she has informed already. Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on 2nd of April, 2/4. Yes, madam. When did you file, Madam Sharma? This morning. Already filed? Okay, bring it. I did bring you one supplementary. You should really have it. Huh? All of did you? This is what maybe. Yes, Mr. Warren. You are Patadar. Where is the patta? Where page? But this is tribal belt and block.
Yes. Then put the emperor upon the one, but the owner in the year 19 procedural code. And then
Which page? Which page? Page? (23). 23 is the voters list. We are not on the voters list. We want to see the land document. Land document. Where? Page?
Right.
29 is what? What is 29? We are not on Jamabandi. We are on the Patta. We are on the title. We are not on Jamabandi. Will not give you any vest you any right. Let us see the Patta. Which Patta? Where is that Patta? No, where is that Patta? On the basis of Jamabandi, we cannot determine right.
Next patta, and it page 37. Number 39. It's 37. And illegal. Usually can be turned to page 34. After that, the owner, this son. Page 34.
So, Bora, why do you highlight the pages before you when you present to the court? Who has highlighted these pages? Who has highlighted? Why do you give highlighted copy to the court? No, this is not the way to present a petition. It may be your copy. We are not concerned with your copy. Please do not highlight. Whatever is to be highlighted, you can submit. We'll take note of it. There is no question of using highlighter of this nature. Now, where in page 37, where is it? Your names? Names? Serial 34. Page 34. No, you have taken us to 37. Page 37. Recent patta. Where? (44). Serial number? Yes. Yes, madam. Because similar cases we have not entertained, but this appears that they were granted patta since the time of their ancestors, predecessors. Now it has been continuing. What do you say on this? No, yesterday was different. Yesterday, one case, there was a sale deed. Sale deed. And there was another case where there was no seal deed, it was based on power of attorney. We did not entertain power of attorney. But here, petitioner is claiming that there is a patta. Can you have Mr. Borpujari? He was in the other matters. After a while, Mr. Bora, since he is appearing in the other matters, no, if they are in occupation, lawful occupation since before the declaration, then their cases might have to be treated in a different manner. Let Mr. Borpujari come. After a while, Mr. Bora. I can one. For rejoinder. Against 7. One of both. Okay. 3 M.R. Khandakar, learned counsel for the petitioners. Prays for has renewed his prayer for grant of further time to file rejoinder affidavit against the affidavit in opposition. Affidavits in opposition filed by the respondent number 1 and 7. Full stop. Matter accordingly stands adjourned by 3 weeks. 3 weeks to enable filing of such rejoinder affidavit. Okay. Sri N. Goswami, Learned State Council. Ms. P.R. Mohanto, Learned Revenue Department, Standing Council Revenue, and Sri L.R. Mazumdar, Learned Council for Respondent number 7 are present. List on. We give a date. 3 weeks, you have said. 1, 2, 3. We'll have it on 7th of April. Not 7th, 8th of April. I get to. What is the matter, Dr. Saraf? Okay, well, yes, when do you want? Can you have it today? When? Huh? Okay, we'll try after a while. Mr. Saraf, after a while, we'll try. $17. Yes, 70 is not before. Please before any other bench or 17. I didn't see and prove. Four in response number 4, item number 4. 3 you have filed. Okay, let him file the. Okay. You are BC Basumatari, Musahari. Okay. I heard 3 as Bothakur, Learned Counsel. for the petitioners in these cases. Full stop. Sri B.C. Musahari, Learned Standing Counsel BTC, has however informed that though affidavit in opposition has been filed in WPC 2092 of 2023, such affidavit has not been filed in WPC 1110 of 2023. Full stop. He, however, submits that the affidavit is ready and will be filed shortly. Full stop. Accordingly, matter is adjourned by 2 weeks to be listed on 27th of March, by which time the affidavit in opposition is required to be filed. Okay. Interim order passed early, hence extended till the next date of listing.
Item 21. Thank you.
Mr. Borpujar, Madam was here, but since you were dealing with the other matters, we thought that your presence would be of assistance. Here they are relying on a patta even before the independence, and they are the successors of the original pattadas. Jamabandi they have enclosed, and Jamabandi has also disclosed in patta number. Her name is there in the new patta. We found at page 44, serial number 90. Yes. Rehna is number 2. Yes. Yes. Where? Which page? Where is he? Where is he? No, where is Kutubali? Where is he as a petitioner? Why Kutubali is not before this court? Passed away. Where have you stated? This is a Jamabandi of which year? The date of death? When did Kutubali pass away? Two 2015. And this Jamabandi is of which year? Kutubali's name is at which page? Page 40?
second, seven.
Yes. Where have you stated that Kutubali passed away? Where? Page 15. Page, para 15.
It is on page number 6. There is 8, there are 6.
Why twice? Why it is twice? Where is the family history? How did it devolve upon you? Where have you stated? 8. You have given the genealogy.
And we had several of them in the district of unwedded town in different places. At the time of death of Lopan Devan, we had their 2 sons, namely Satyavati Devan, Satyavati Devan. Both have already died. At the time of death of Satyavati Devan, we had their 4 sons, that's it, Akbarali Devan, Yosavati Devan, Petali Devan, and Mubin Ali Devan. Out of that, we had 4 sons, Satyavati Devan. These would have already been died, except Mohinali Devan. At the time of death of Satyavati Devan, we had their 2 sons, and one other, namely Satyavati Devan, son and Behena Begum. One of the petitioner and the Begum. Wife Satyavati Devan. How they can improve because something the owner of land. Yes.
Can you take instructions? We'll have to issue notice, some guns for protection. Because see, these paragraphs are substantiated by the annexures, which no doubt are Jamabandi, but it refers to a particular patta. And how it has devolved, the name of the ancestors have been given. 37, yes, 37 we are having, yes. No, but he's trying to project a different case. That prior to independence, Ratan Ali was in occupation before declaration of this tribal belt and block. And it has devolved on the present petitioners. In those cases, how do you deal? There are existing. See, yesterday in these days there are 2 kinds of cases. One, on the strength of some power of attorney, we have not given any indulgence. One was the case where he had purchased registered deed. Whether such registered sale deed would be valid ultimately will be a question to be answered. But prima facie, he has a case that he had purchased. So we'll have to try to make strike some balance. Okay. Heard. 3 L.K. Bora, Learned Counsel, for the petitioners. Full stop. The petitioners claim to be to be the legal heirs of the original owner of the plot of land covered by Patta number 39 of Revenue Village Pachonia Para under Moza, Dakhin, Rani, Azara Revenue Circle. Full stop. They are aggrieved by a notice dated 27/2/2026, by which they have been directed to vacate the land on the ground that the land falls within the tribal belt and blocks. Full stop. Para. Sri R. Borpujari Learned Standing Council Revenue has, however, submitted that in similar cases, writ petitions have been dismissed. Full stop. Sri Bora, the Learned Council for the petitioners have, however, submitted that the cases which have been dismissed are based on certain power of attorneys which were executed much prior to the creation of tribal belt and blocks, whereas in his case, the land is in continuous possession since the time of their predecessors, and a valid patta has been issued. Para. Let notice be issued, returnable on all official respondents or on 6th of 6th. Is it okay? 6th. You get the 6th of April. 6th of 3. Who will, Mahanta will accept notice? Oh, no, we have recorded your name. Sri R. Sri R. Borpujari, Standing Council Revenue, 1 and 2, then 3, 4, and 5 by SS Roy, extra copies. Sri Bora, the Learned Council prays for an interim order. Para. Considering the facts projected and also the aspect that there is a patta issued in favor of the petitioners, it is directed that till the returnable date, no coercive action for eviction of the petitioners be taken. It is, however, made clear that the present interim order is passed only with regard to the present petitioners and petitioners. Please return due will have 30th of March. 30. Yes. I can do. Yes. What is this SVL plus? सबका विकास. What is LDRS? Yes, 30. Yes, सबका विकास legacy dispute. Of the petition. Of the petition of the. Yes. At 170. 170 clause 8. Yes. Categories.
Now, on the that was after the.
Why is this date relevant? 36, 2019? No. The that we have read. The date 36, 2019. Rules. Where do we find the rules? At 23. Rule? Where are you reading? Page 23? Yes. Post explanation.
They're right. The same thing covered.
Yes.
On that,
Page 51. Yes, please. Yes. This you are referring to thought bulb, thought blurb. Reported in 2020. This is Bombay High Court. Which page? Second judgment. Bombay. (48) internal page. Para 48. Yes. Yes. What about your the undertaking which you had given? No, that thereafter you will not file any appeal. No, at page in your short note, third page on 5/4/2022, petitioner filed compliance report, reiterated undertaking not to appeal. In the meantime, the show cause notice was already had culminated into the demand of 290. Yes. Yes. Dr. Saraf, see, in a given case, a discharge certificate can also be issued erroneously by some officer or maybe for some other consideration. But here you have another point that the guidelines issued, which you have taken at page 170, has stated that even for matters which are after 36/2019 would be covered. So that is your say, that covers your first. Yes, Mr. Anything else? Yes. Mr. Kyle? 170, yes. I'm making your point, your scope slightly easier. Let us, for the time being, assume, which you probably say, that the recharge certificate, that process was erroneously proceeded by giving benefit to the petition under the scheme. But the explanation at 170, how will you explain? What is your clarification? 170. Yes, please. Desirable. So have you recorded any findings that in spite of that being desirable, you are not going ahead? Page. And what about then we come to the first question? Why did you process with their application under the scheme which culminated into the issuing of a discharge order certificate? No, maybe will not do. If it is an error, what steps have you taken against those officers? No, that first they have to plead that it is erroneous. Number two, then the question will be coming, what action have you taken? Yes. Yes, yes. 4-1 of the petition. It starts at order in original, dated 16/2/2022. Page 41. Yes, please.
And what is that movement in this system? It's equal. Next, the things, the next of the situation helps. That the condition level and therefore, security not present to them, the world amount of publicity. Not needed. Not needed. What you can not secure for publicity. Please condown space of personal attack. Therefore, the solution for not take whether create an escape part of the people. Once they get to that and have you can demand the activity, something kind of official that will not even that along with this. The first offense of full power, the training, and the people come to the ready to give us the kind of person in some instance.
But that is your order. Where is the suppression? You have acted on the scheme. You have passed the discharge. Two point five. Yes. Fail to respond. 36 is not the reply. It is an intimation. I also request to adjudicate my. Yes, we have seen that. Malay Mazumdar, deponent. Yes. But at page 36, there is a clear mention of the scheme in the second paragraph. You have said that he has not contested the proceeding. There is a letter which you have received on 27/12/2019. If it is not construed to be a regular reply to the so-called, but he has specifically stated, I also request you to kindly adjudicate my case as I want to avail the benefit of exemption extended by Government of India. Thereafter, it has been adjudicated, demand made, he has paid, accepted. Then how do you reopen thereafter? No, order in original after this 27/12/2019. When was the settlement done? 4/2/2020. And this order in original 16/2/2022. 22. How can you say that you are not aware? What is your finding on the certificate, discharge certificate? Have you given a finding? Then You have totally ignored the discharge certificate. You cannot say that that is not brought to your knowledge. That is your certificate. No, you have to apply your mind and you say that we are not going to buy this. That you have not done. This is a relevant factor you have not taken into consideration. See, you may be right in contending that discretion was given by use of expression may, desirable. But you had exercised your discretion, had come to a conclusion, discharge certificate is on 4/2/2020. And this aspect has not been dealt with in the ordinary original. In case of on the ground, 36. See, if a party comes to the court trying to enforce that CBDT thing, then you can raise a valid defense that this is desirable, that there may not be an enforceable right. Now, here is a case where you have utilized it, or it comes with the benefit of the petitioner. Okay. Just a minute. Yes, open. Please read. That's an entirely different fact. No, that this propels the Honorable Supreme Court to take a decision. All decisions are based on certain background. Now, the background was that in spite of availing the benefit, the amount was not deposited. So, if this is the background, a particular decision will be taken. If the time is extended. Yes. Okay. Correct. Okay. The challenge instituted in this petition filed under Article 226 of the Constitution of India pertains to an order dated 16/2/2022 passed by the Assistant Commissioner, GST and Central Excise, Gauhati 1 Division, and the subsequent order dated 6/12/2022 passed by the Commissioner within bracket Appeals, CGST, whereby the appeal has been rejected. Full stop. Para. As per the facts projected, the petitioner is a proprietor of Messrs. School Tech Systems within bracket Assam and has been provided the status of a service provider for the finance provider. Full stop. The relevant period is the financial year 2014-15. Full stop. On 7/11/2019, a demand cum show cause notice was issued under section 66B, capital B, 68, 69, and 70 of the Finance Act 1994, read with rules 4, 5, 6, and 7 of the Service Tax Rules 1994, with the allegation that services worth rupees 23,47,386 was due for the period for the concerned period, and accordingly a demand of rupees 2,90,137 including cess was made. Full stop. The petitioner had submitted a reply on 27/12/2019, whereby it had accepted the demand and agreed to pay the same. Full stop. However, the petitioner had also requested to be given the benefit of the SVLDRS, 2019, pura likhiba, sub ka vikas within bracket legacy dispute resolution bracket close scheme 2019. Full stop. Atar bracket likhiba SVLDRS. Full name to prothomta likhiba bracket short form. Accordingly, the petitioner had filed SVLDRS 1, which was acknowledged on 31/12/2019. Full stop. Consequently, the designated committee, after consideration of the matter, had issued SVLDRS 3 and determined the amount payable as rupees 1,16,054.80, which was paid on 20/1/2020. Full stop. After such payment, SVLDRS 4, which is the discharge certificate, was issued on 4/2/2020. Full stop. According to the petitioner, after issuance of such discharge certificate, which is not in dispute, the matter had come to a conclusion. Full stop. However, the Assistant Commissioner had passed an order in original on 16/2/2022 and confirmed 2022 ex parte and confirmed tax of rupees 2,90,137 along with penalty under section 77 and 78. Full stop. It was recorded in the said order that the petitioner had failed to respond to the show cause notice. Full stop. After such, why is it 5/4 before the order? Why is your response on 5/4/2022? The order was passed on 16/2, ex parte order. It has to be before the said order. No. Okay. 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 Having come to know about the aforesaid development, the petitioner had submitted a compliance report on 5/4/2022 and had reiterated the undertaking not to refer any appeal so far as the settlement of the matter vide issuance of SVLDRS 4. Full stop. Accordingly, an appeal was filed before the Commissioner Appeals, putting to challenge the order in original dated 16/2/2022, which was also dismissed on 6/12/2022. Full stop. The primary ground of dismissal of the said appeal was that the SVLDRS was not applicable as the show cause notice in the instant case was issued on 7/11/2019, which was after the prescribed date of 30/6/2019. Full stop. The appellate authority had relied upon the explanation. Where is the explanation? 3.2. Explanation to Rule 3 within bracket 2 of the rules of 2019. Full stop. It is the aforesaid actions which are the subject matter of challenge in the present petition. Full stop. I have heard Dr. A. Saraf, Senior Counsel, London Senior Counsel, assisted by Sri A. Kaushik. I have also heard Sri S.C. Kayad, Learned Senior Standing Counsel, CGST. Full stop. Dr. Saraf, the Learned Senior Counsel, has submitted that though a show cause notice was initiated on 7/11/2019, the petitioner vide a written application dated 27/12/2019 had requested benefit of the SVLDRS 2019. Full stop. The said request was duly considered, and after completion of all the formalities, the amount was determined, which was paid, leading to issuance of the discharge certificate on 4/2/2020. He submits that after issuance of such discharge certificate, the matter could not have been reopened, which reopened as the same is not authorized in law. Full stop. He has submitted that though, as a matter of fact, no specific reply to the show cause was filed qua the show cause notice, comma, it was brought. Where is that order? Where is that reply? 36. It was a communication was issued on 27/12/2019, whereby the aspect that the petitioner wished to avail the benefit of the scheme was clearly mentioned. Full stop. Nonetheless, comma, the order in original, nonetheless, the proceeding was the matter was proceeded ex parte, and the order in original was passed. Full stop. He has submitted that in the said order there is no reference to the aspect of issuance of the discharge certificate, which was done on 4/2/2020. Full stop. He has also submitted that, no, don't say. With regard to the appellate order dated 6/12/2020, the Learned Senior Counsel has submitted that the finding that SVLDRS is not applicable to the proceeding is not legally tenable, in as much as there is, which page? There is a clear mandate of the Central Board of Indirect Taxes and Customs, within bracket CBITC, dated 12/12/2019, that even for cases where show cause notices were issued on or after 1/7/2019, such cases where is the aspect? 19, it would be desirable that the taxpayer in such cases also be given an opportunity to avail the benefit. He has submitted that it is not the case of the department that such application was rejected at the threshold. Full stop. On the contrary, the application made on 31/12/2019 was duly processed, amount determined, paid, and discharge certificate was issued. Full stop. He accordingly submits that the said that the aforesaid ground of the appellate authority is unsustainable in law. Full stop. In support of his submission, the Learned Senior Counsel has relied upon the following decisions. Number 1, 1-2-3. In the case of thought blur BLU or Visailov, page 1. Or 51. The following observations have been made by the Honorable Bombay High Court, which have been pressed into service. Para 51 and 52. 40 also. Para 40 लिखिबा. 40. It is submitted that it has been clearly laid down that once a discharge certificate is issued, comma, the declarant shall not be liable to pay any further duty, interest, or penalty for the period. Full stop. In the case of Astula, it's available next term. Next case to about, comma. The Honorable Bombay High Court has made the following observations. Paragraph into 48, 48. What's the yes, paragraph 48 to quote page 31 for a compilation of modified blue color mark for us. 3. What is there in 62? Reliance has also been placed on the observations made in paragraph 62, which deals with the objective of the scheme of the SVLDRS, which is to strike a balance to reach an amicable resolution of tax disputes. For ready reference, 62 quote kore diba, Per contra, comma, 3. Kyle, the learned counsel, the learned standing counsel. Of full stop. This court is of the opinion that though the expression used is desirable, comma, the ultimate purpose is to bring a resolution of all such disputes by giving benefits to taxpayers, to assessors who have been issued show cause notice on or after 1/7/2019. Full stop. Para. So far as reliance upon the decision of the Honorable Supreme Court dated 18/2/2022 is concerned, comma, a bare perusal of the order would show that the facts are entirely distinguishable. Full stop. In the said case before the Honorable Supreme Court, comma, the aspect was with regard to extension of time beyond the period prescribed by the scheme, which the Honorable Supreme Court had refused to do, as the same would amount to modifying the scheme, which is within the domain of the government. Full stop. In the instant case, comma, the records clearly indicate that the scheme was that the application for availing the benefit under the scheme was duly considered and a discharge certificate was issued on 4/2/2020 after payment of the amount determined. Full stop. In the view of the aforesaid facts and circumstances, comma, this court is of the opinion that a case for interference is made out. Full stop. Accordingly, the impugned order in original dated 16/2/2022, which has been affirmed by the appellate order dated 6/12/2022, stands set aside and interfered with. Writ petition stands allowed. Yes. I was filed by? Okay. You want to do it today? We'll do it. Which item? We'll do it. After a while, let Dr. Saraf take a cup of coffee. He also comes fresh. Okay. That will be very unfair to the court. খালি দিলো নেকি নিদিলো ন খালি ক'ত ক'ত যে থাকে নহয় হা Yes, Mr. Botakur, Mr. Gogoi, what is it? Item 5. You challenge that will grant you liberty. But you have already been evicted. But you have already been evicted. Now, understood, but is it a matter of fact that you have already been evicted or not? Partly evicted. How many of you are there? One petitioner. How is one petitioner partly evicted? Yes, Mr. Goswami, what has happened? Where have you stated? You have stated. We'll say that in case he is in possession of any part thereof, you follow the due process. That's all. Why should he keep this pending? Your D. Gogoi heard 3 D. Gogoi Learned Counsel for the petitioner. Also heard 3 N. Goswami Learned State Counsel and Miss Anne Bodloy for Learned Standing Counsel, Revenue Department. Full stop. Para. 5 is there. Who is 5? It's in Kamrup, Gauhati property. Okay, as Bora, Standing Counsel, GMC. Para. As per the facts projected, comma, the petitioner is in possession of a plot of land measuring 1 katha. Please have your seat. 1 katha, 5 lacha, covered by DAG number 1084 at Ulubari Gaon Revenue Village under Gauhati Revenue Circle. Full stop. It is contended that the land was purchased by executing a sale deed in the year 1980. Full stop. It is also contended that being in possession for more than 10 years, the petitioner had applied for settlement. Full stop. However, on 29/2004, the respondent authorities had come to the premises and demolished the entire construction. Full stop. The aforesaid action was the subject matter of challenge in a writ petition WPC 8034 of 2004, whereby a direction was passed on 7/11/2012 directing the Deputy Commissioner to consider the application for settlement of land with the petitioner until such consideration is made, comma, she should not be evicted from the land in question. Full stop. However, it is the case of the petitioner that without complying with the aforesaid judgment, comma, on 29/4/2023, comma, some part of the house of the petitioner was demolished. Full stop. Accordingly, the second writ petition has been filed. Full stop. Sri Gogoi, the Learned Counsel, has submitted that the impugned action is in gross violation of law and also the principles of natural justice. He has also alleged that the earlier order of this court dated 7/11/2012 has been violated. Full stop. Para. Sri Goswami, the Learned State Counsel, on the other hand, by referring to the affidavit in opposition dated 21/1/2025, filed by the respondent number 3, has submitted that the eviction process has already been carried out as the land in question is a part of the cremation ground as well as within inverted comma GAU Go Reserve within VGR. Full stop. It is submitted that the petitioner was in illegal occupation and the eviction has accordingly been carried out by following the due process of law. Full stop. Para. Both Miss Bordolo, the learned standing council revenue, and Sri Pora, the learned standing council GMC, has endorsed the submission advanced by Sri Kosami, the learned state council. Full stop. Para. Sri Gogoi, the learned counsel for the petitioner, has submitted that in view of the aforesaid stand, there may be a fresh cause of action which the petitioner may challenge if so advised. Full stop. He, however, contends that the eviction has not been carried out completely and some parts of the land is still in possession of the petitioner, correct? Full stop. Para. In view of the aforesaid situation, while this court is of the opinion that no relief as such can be granted to the petitioner in this case, liberty is granted to the petitioner to challenge the consequential action before the appropriate forum. Full stop. It is also provided that if any part of the land is still under the possession of the petitioner, which according to the state respondents are government land, reserved land, which are to be made encroachment free, the principles laid down by the Honorable Division Bench in the case of Salekuddin versus so-and-so, reported in so-and-so, interpreting regulation 18 of the Assam Land and Regulation, interpreting Rule 18 of the rules framed under the Assam Land and Revenue Regulation 1886 be meticulously followed. It is also submitted. He has also submitted that the application for settlement of land has also been rejected, as the land in question is a part of the grazing land. Grazing land, what? Go reserve is grazing, vizier is vizier land. Go reserve land. Go reserve land. GAU, that's reserve.
Item 6.
Mr. Doctor, who is 6? Who is GST, Mr. Chakraborty? CGST or central or state? But you said GST is the issue. State GST or central GST? Who is for Public Post Department? Name shown or not? Yes, shown. Where is Madam Sharma? Yes, Sharma.
Prepared by the department as per the details given by me. While preparing the bill, posting the bill, finally the department has to add the GST. The state is the last certificate of rural services that GST was formed of state. Therefore, state should, as the GST has given to me, the state has never given GST to me, and I have paid GST to apply. As per law, the contractor was the GST given by the government. So,
but what about the proof of making such deposit by you? Such payment of GST by you? No. The aspect that you had made a payment which is to be reimbursed by the state by adding in your bill. You have to have some documentary proof that you have made the payments. How much is the amount? But your the bills which by which you have made the procurement of any goods, it will have a GST component which you have paid. That is only you are entitled for a reimbursement, kind of a reimbursement by putting it in your final bill. Running, okay. But where is public cost? No, an analogy of the forest royalty is almost the same. Almost the same. If you can show that you have paid the forest royalty, you are entitled to get the benefit. GST is also the same. But who's Mr. Hendrik? Have you informed Ms. Madam Sharma, PWD? Normally, who appears? Sharma, Madam Sharma appears, or from PWD? Nath. Public Works Department, normally Madam S. Sharma is appearing. Or B. Gogoi is also there, or what? Order. Okay. Okay. PWD has filed affidavit. No response. Then we can pass orders in this 23 matter. P. Nayak. Why have you filed additional affidavit? Component. Okay. Wait for a while, Mr. Chakraborty. Let him come. Yes, Mr. Patgiri. No, what about the mediation drive? Are you interested to resolve the issue by mediation? Who was the mediator? Huh? Purnima Borua Bodole. For 3 days. 3 days they have appeared. Why don't you appear? You have not appeared for 3 days. This is not done. But were you aware of this mediation? You were aware. This cannot be done. You cannot put the petitioner to harassment like this. She comes for 3 days. Now, can we decide the matter? What is the issue? You are the BPCL. Now he was issued a retail outlet. Then he constructed. $40 lakhs. 200 meters. Why 200 meters? We don't find 200 meters. No. Why is it required that your petrol pump has to be recent guidelines? Is it recent? But that will not, a bidder who bids for such a outlet, cannot contemplate that another huge amount would be, has to be incurred by him. No, we are not finding fault with you. If road is necessary, it will be necessary, but who will bear the, who will construct the road? At whose expense? Huh? Did you indicate in the, where? In the NIT? 20. So while submitting the bid, the bidder was aware of this aspect. Clause 6. Where? Meaning what? What is the meaning? But this is very vague. 3, 4. Yes. Seven B, in case. Driveway. But your amount will be forfeited. How much amount have you deposited till now? Have you invested anything? 4 lakhs. For? Have you made any development of the land? No. Then we'll close this. He makes an application. He makes an application for an applicant for and surrender, as well as he'll make an application. If you can, you'll consider that by speaking order. We cannot direct for refund because in the he had taken a whole process. Okay. Heard 3 K.R. Padgiri, learned counsel for the petitioner. Also heard 3 S. Bothakur, learned counsel. No, first Union of India, sir. Also heard Union of India, who's there? Ministry of Petroleum. Any CGC in the court? CGC, any CGC? Also heard 3 A.K. Doctor. Learned CGC, no, also heard 3 S. Bothakur, learned counsel for the BPCL. 3 C. Barua, learned counsel for standing counsel for NHAI, and 3 A.K. Datta, learned CGC. First of, okay, the state is there. J and N code there, and J and D, learned state council. Revenue is also there, not there. Revenue is not there. Correct? The instant petition has been filed with seeking the following relief. Page 17, prayer quote kariye. Para. as per the facts projected, comma, pursuant to an advertisement dated 31/10/2010, published in the Assam Tribune by the BPCL for appointment of retail outlet dealership in various locations in the state of Assam, comma, the petitioner, who claimed herself to be eligible, had applied for such appointment for the location against serial number 15, correct? Full stop. Accordingly, comma, after completion of formalities, the petitioner was found suitable and letter of intent dated 3/6/2011 was issued in her favor. Full stop. Subsequently, NOC dated 15/12/2011 was also issued with the permission for lease of the land in question. Full stop. It is however projected that the retail outlet was not installed within the period of 1 year, and in the meantime, comma, the NHAI had requested to submit fresh proposal as per the guidelines. Full stop. Though the petitioner has claimed to have submitted all the land documents, comma, no steps was taken to lease out the land as well as to install the retail outlet. Full stop. Para. 3. Adgiri, the learned counsel for the petitioner, has submitted that the petitioner has in the meantime deposited the security amount and of rupees 3 lakh and a further amount of rupees 1 lakh for other heads, in spite of which other heads, in spite of which, comma, no steps have been taken for installation of the retail outlet. Full stop. He has, however, submitted that another aspect had cropped up with regard to the approach road, and it transpires that the development and construction of the approach road, which is about a distance of 200 meters, have to be borne by the petitioner. Full stop. He has categorically submitted that the said aspect was not within the contemplation while submitting the bid and would otherwise incur a huge expenditure which is beyond the capacity of the petitioner. Full stop. Para. 3. S. Bhattakur, the standing counsel BPCL, has submitted that in the advertisement itself there was sufficient indication regarding the development of the site, which has to be at the cost of the petitioner, cost of the bidder. He has also submitted that there are other documents, including the, which one you have said? One more page you have said, sure. Huh? What is this? No, what is this 34? No, what is part of the advertisement? He has also drawn the attention of this court to clause 7 of the advertisement, which is with regard to provision of basic facilities at the retail outlet. And under subclause B, there is a clear mention of development of the land, driveway, compound wall, etc. Full stop. Para. Sri C. Barwa, Standing Council NHA has submitted that the guidelines have been issued in the public interest and such guidelines are otherwise also not the subject matter of challenge. Full stop. Para. This court, on noticing the dispute, had also referred the matter for an amicable settlement by mediation. Full stop. However, the mediation had failed mainly for the reason that the officers of the respondent BPCL did not attend the same. Full stop. Para. However, Sri Bothakur, the learned counsel, has submitted that due to certain miscommunication, the mediation could not be attended. Full stop. Para. Sri Padgiri, the learned counsel for the petitioner, has reiterated that as per instructions received, it would not be feasible on the part of the petitioner to incur to construct the road, which would incur a huge expenditure. Full stop. He accordingly submits that he may be allowed to surrender the LOA so that the aspect of allotment can be taken forward by the BPCL by appointing any other person, suitable person, for the said purpose. Full stop. He has also submitted that a liberty be granted to file an application for refund of the security and other deposit. Puts the para. After considering the facts and circumstances, this court is of the view that since public interest is directly connected with the installation of the retail outlet, further delay would not be in sync with such requirement. Full stop. Accordingly, this court allows the petitioner to surrender the letter of intent. Full stop. As regards the prayer for consideration of refund of the security and other amount, this court is of the opinion that no mandamus as such can be issued, as the same would depend on the and the same would be a matter within the domain of the BPCL, which had floated the tender process. Full stop. However, it is observed that in case such an application is made, the same may be considered in accordance with law and disposed of by a speaking order. Full stop. Petitioner stands disposed of. What is it? Covered? Not covered? Huh? Okay, then let same set of facts, CGST and GST. Res judicata, is res judicata applicable in a proceeding under GST? Principles of res judicata, I would say. Okay, let Mr. Kyle come. Okay. Ask him to come, we'll try to dispose of this matter. Let's see. Yes, next. PW has come, Mr. Chakraborty. Oh, yes, Mr. Chaudhary has come.
Item 6.
For 23 matter, we are in 2026. And first matter was filed early 2580. Maybe in April it has been filed. When was it filed? March. Yes, 3 years. 3 years have passed. 8th of, no, May. 8th May. No, 8th May you had filed. From the date of filing, we had said that almost 3 years have passed. If Mr. Nayak is handling, we will not burden Mr. Chaudhary with this. We are not passing any orders, Mr. Chaudhary. You have a consultation with your colleague also. And if you agree upon this, then we can dispose this off. Otherwise, we'll grant you some time to file the last opportunity to file the. But if it is covered and the issue is the same, then no point of adjourning. You come after a while. Mr. Datta, for whom? This case only. Oh, no, you may not have a important role. The Public Works Department. Okay. Come back after a while, maybe at 2 o'clock. Who are we to make you captive? You're already free. All men are free. Released. No, if you want time to file affidavit, we'll grant you more time, but at the last opportunity. But if you want, if you consider that it's covered, the issue is covered, then we can dispose of today itself. For that purpose only, you come back, either you seek time or you say it's covered. Okay. Yes, next.
Item 9.
Okay.
Since last 8 years, now, the safety alert, get to the 19.
When did he apply for Patta? When did he apply? When did he apply? When did he apply? Application for restoration of old Patta. 19/6/2023. What happened thereafter? What is the nature of the land? Khas land. But that but the conversion was not challenged at that relevant point of time. So you had filed an application for restoration of the old patta. What has happened thereafter?
That is correct.
Okay.
Now, Petrol has filed our reply. Sorry, everything from petition. But admitting the petition as that verdict.
What is your prayer now?
Now, my application is let my application be disposed of. So also the cover by identical order as well as before. And the coordinate is also without
This was on a different aspect. There was names of third party recorded. This is not your case. What is your stand, Mr. Who has filed affidavit? You by circle officer filed. When did you file? 1/9/2023. Circle officer of which place? Yes. Okay, we'll come to you. Let. Not patta. Oh, not patta. He is saying restoration of patta. Just a minute, please. Paragraph 4 you have said. Pashu and Sabu. Pashu and Sabu. Repetition back to state at revenue. Now, this petitioner is the descendant of this Pashu and Sabu. No. He is the grandson of Pashu. Now, this conversion had taken place when? Of the repetition. No, but what is your stand? The regard to the paragraph 2 of the representative states that land measuring 3 bigha, 3, 5, 4, 3 bigha, 2 katha, 10 lesser covered by the. What is your then? What else? What is the prayer, Mr. Mondal? $75, but are you in position? Number 8. We dispose this of. The present petition under Article 226 of the Constitution of India has been filed with the following prayers. The prayer quote कर लीजिए हैं. Mark क्या है page 10. As per the facts projected, comma, the petitioner is in possession of land measuring 2 bigha, 3 katha, 12 lecher, covered by Dag number 197 within bracket old /214 new Khatian number 76 at village Halukmari under Bilasipara Revenue Circle in the district of Dhubri. Full stop. It is contended that the land is under his possession since the days of his great grandfather. Full stop. It is the case of the petitioner that the name of the grandfather of the petitioner, late Pashu, Pashu, SK Sheikh, was recorded as a Khatiyandar under the Gwalpara Tenancy Act 1929. However, in the year 1975, the land was declared khas without assigning any reasons. Full stop. The petitioner, being the legal heir and having valid claim, had accordingly submitted an application for restoration of the old patta on 19/6/2023. Full stop. The same not having been acted upon, the instant petition has been filed. Para. I have heard Sri M.U. Mondal, learned counsel for the petitioner. I have also heard Sri J. Hendrick, learned state counsel, and Miss N. Bodeler, learned standing counsel, Revenue Department. Para. Sri Mondal, the learned counsel for the petitioner, has submitted that it is not in dispute that the plot of land in question is under the continuous possession of the petitioner since the time of his great grandfather. He has also highlighted that the conversion in the year 1975 was done without assigning any reasons, and therefore his application for restoration of patta is liable to be considered. Per contra, the Sri Hendrick, the London State Council, has submitted that the projection made is wholly incorrect. Full stop. He has submitted that though the records would indicate that the great grandfather of the petitioner was in possession of the land, such possession was only as Khatiyandar. Full stop. However, in the settlement operation made in the year 1975, the area was converted and recorded as government khasland. Full stop. He has submitted that such action was not put to challenge by any person, and it is only after a long delay of about 50 years that the instant petition has been filed. Full stop. He submits that on the ground of delay itself, the petition is liable to be dismissed, and otherwise also the petitioner has not been able to demonstrate a case of violation of any enforceable rights. Full stop. Para. Ms. Bodeler, the learned standing counsel, Revenue Department, has endorsed the submission of the Learned State Council and has reiterated that no enforceable right has accrued to the petitioner to claim possession, to claim settlement of the land. Para. Sri Mondal, the Learned Counsel, in his the men handicap. Okay. So the Learned State Council has also submitted that affidavit in opposition has been filed by the respondent number 6 circle officer, Vilasipara on 1/9/2023, which has not been rebutted by the petitioner by filing any rejoinder affidavit. Then Bodeler आएगा. Then it's called Mondal. Sri Mondal, the learned counsel, in his rejoinder, has submitted that from the affidavit of the response number 6, the aspect that he is the that three pass that Pasusik is the predecessor of the petitioner is established. Full stop. He has also relied upon an order dated 22/6/2023 passed in WPC 3625 of 2023 within bracket Zafil Alag Uddin Alag Ahmed versus State of Assam and others, and has stated and has submitted that the facts in that case are identical. Full stop. Para. The rival submissions have been duly considered and the material space and so on. Para. The projection made in the petition as narrated above is that the predecessor of the petitioner, one Pasusik, was in possession of the aforesaid plot of land. Full stop. It, however, transpires that, contrary to the projection made, that Pasusik was the Pattadar, comma, he was only the Khatiyandar. Full stop. It is also evident from the materials on record, including the averments made in the affidavit filed by the respondent number 6 on 1/9/2023, that in the settlement process, in the what do you call resettlement? What in the settlement operation, comma, the land was converted. Land was converted as government khasland, and a new dog number was recorded. Full stop. For any reference, the relevant averment made in the said affidavit averments are extracted herein below. Page 25, para 4. As indicated above, comma, there is no rebuttal affidavit filed by the petitioner. Full stop. The other important aspect which confronts this court is the aspect of the gross delay in approaching this court. Full stop. The cause of action, comma, if any, accrued in the year 1975, and this writ petition has been filed after about 50 years in the year 2023. Full stop. Para. Be that as it may, comma, even from the records, it transpires that the status of the land has been made khas, and the state khas in the year 1975. 75. Full stop. In that view of the matter, first of all, so 75. Full stop. Para. So far as the order dated 22/6/2023 passed in WPC 3625/2023 is concerned, which is relied upon by the petitioner, comma, this court has noted that the facts are not identical, as in that case, comma, there was an allegation that the names of certain third parties were entered into the revenue records. Full stop. Para. However, this court has also noted that in the said order, comma, so far as the relief sought was concerned, comma, the same was declined, with the only observation that the petitioner can apply for settlement under the existing land policy of 2019. Full stop. Para. Considering the above, comma, this court is of the opinion that no case for any interference or relief is entitled, interference is made out, and no relief can be granted to the petitioner. Full stop. Writ petition accordingly stands dismissed. Full stop. Para. The petitioner would, however, be at liberty to file appropriate application for for allotment of land as per the land policy of 2019. And if such application is submitted, comma, the same is directed to be considered strictly in accordance with law. Is there an interim order? It was not interim order stands vacated. It was not extended, otherwise it stands vacated. We want to use the word dismissal in this case. Uh, 1516 was what? Okay, that matter. When can we have, tell us? Both? 20? 3rd or 4th April? 23rd? Okay. Okay, we can have it. We can try on 24th. Part 3, K.K. Mohantal Senior Counsel for the petition assisted by Miss N. Begum. Also heard 3 R. B.J. Talukdar, Learned Addition Senior Advocate, and 3 you're for item number 16. Your Das, your name is not there. Your name is not shown, Mr. Das. Item 15. Okay. Also heard 3 B.K. Das, Learned Counsel for the petition in the connected WPC 6133 of 2013, full stop. Wide the earlier orders, comma, the relevant records were directed to be obtained, full stop. Sri Talukdar, the Learned State Council has submitted that though it appears that the records have been transmitted, comma, he prays for some time to go through the same. Para, in view of the above, matters are adjourned to be listed on 24th March.
Item 6.
Is it covered? Okay. Heard 3. Which is this item, Mr. Chakraborty? Heard 3 B. Chakraborty, Learned Counsel for the petitioner. Also heard 3 A.K. Datta, Learned. Also heard 3 B. Chaudhary, Learned Standing Counsel PWD, and 3 A.K. Datta, Learned CGC. 3 Chaudhary, the Learned Standing Counsel. Don't say like this. 3 Chakraborty, the Learned Counsel for the petitioner, has submitted that the issue would be covered by a decision of this court, which he relies upon. Full stop. Sri Chaudhary, the Learned Standing Counsel, has however submitted that the facts of that case are distinguishable and he would like to file an affidavit. Full stop. Para. Considering that this writ petition is pending since the year 2023, our last opportunity of 2 weeks is granted to the Public Works Department to file its affidavit in opposition. Full stop. List on 2 weeks. We'll have it on 30th of 30 March. On 26 years. Mr. Dr. Saraf, Mr. Kyle, What covered matter? IA is there, your IA. Okay. You had filed your objection? See, Dr. Saraf, there are two aspects. First, whether the order passed, what was the stage when the order was passed? Number one, that is one consideration. Whether the order was passed ex parte quo applicants who are presently before this court praying for modification. Second, and third, whether the order was passed in his presence. So first is that it was passed at the motion stage. So motion stage means without instructions. Admittedly, it's not an ex parte order, quasi present respondent. So per se 226(3) may not be applicable, that 15 days, fortnight automatic vacation. But if he is equipped with certain instructions, which he probably was not equipped with at the time of moving the petition, he perhaps there would be no bar in law to move an application. Appeal is okay. He would be appeal if there is a consideration after hearing him. This was primarily after hearing you. So we'll give him a chance. Yes. Cash. That was accepted. Okay. Be deposited. Review kind of a thing. Okay. In the order, interim order, this is reflected. It is on the same ground now. That will be not be very strict because that was at the motion stage. He was not equipped with the instructions. Now he is equipped with instructions. Yes. IA 705 of 26 SCKL.
So what happened on that day, there were two witnesses were moved. In one fact, there was a difference of 2,000 cases. In another, for your say, there is a difference of 28,000 cases.
Difference means?
What's it the goods not in fact because they were not supported by valid documents.
Okay, there was excess load of 22,000 kilos.
In this case, what's may come to page 11.
22,000?
Yes, sir. 22,215 cases. And in another case
Of what?
of Areca nuts.
Areca nut. Okay.
What's it come to page 11.
Of the IA.
Yes.
Yes.
Here it look. Since the petitioner has violated the GST rule 138A1 by non-issuance of e-bill.
First, let us read the interim order.
Notes.
And then we'll have a fair idea. Which page?
Page 20. Start
Two-
from page 20.
20.
Question come to paragraph 8. Page 24.
Interim order. That is 22/1/06, 26.
22/1/2026.
318. Yes, please read.
Paragraph 8. Page 24.
Paragraph 8.
Okay.
Meanwhile,
Yes. Meanwhile, considering the submission made by the petitioner, and more particularly the judgment placed into service, wherein it has been clearly held that the difference of opinion in respect of abatement or weight of the consignment ought not to have been sole ground for seizure and contemplated confiscation of the goods in question, more particularly when these goods are perishable in nature. Please also notice that there is no allegation against the petitioner that these goods in transit were not supported by adequate documents and or they were fake documents or there was absence of any detail of the dealers or forced e-bill or are completely decisive, diverse,
deceptive.
or complete mismatch.
Deceptive.
Lots. This is and or fake registration. The court is therefore is a prime view that the following
Subject to.
furnishing of adequate bank guarantee before the respondent number 2 to cover the demand of tax source paid nearly 2,26,038 respective of the GST and SGST amounting to rupees 4,52,000. The petitioner, the consignment of Oregonats along with the vehicle number so and so, 2 vehicles were mentioned, shall be released properly. Now Lordship may come to page 11.
Page 11.
Yes, sir. I found this case.
Yes. Yes.
Since the petitioner has highlighted the GST rule 130A1 by non-issuance of e-bill corresponding to excess goods of 22,215 kgs and more, in accordance with the provision in section 130 of GSTA, MOB 10 notice was issued for compensation of the goods and vehicle and proposing the following: the quantum of penalty and fine totaling to rupees 99 lakhs 45,656. However, the annual court has allowed degrees of the vehicle on furnishing of bank guarantee of rupees 100. And table is there. And next paragraph. 5.5. The petitioners claim that the excess goods of 22,215 kgs could have resulted in nuts consignment was weight and with bags, in which the consignment was paid devoid of logic. The consignment of nuts was baked in 300 bags, which could have not been logically contributed to excess weight of 22,215 kg, which was observed during the physical verification. So Lordship, what happened? There were 2 repeats were more. In one track, there was a difference of 2,000 in some cases. The contention the petition was that the weightment may be varied due to weightment of the goods along with the bags. But in the second case, Lordship, it was 22,215 cases. So this is we want a Lordship of release. We are ready to release the vehicle on furnishing, but the amount is to be different. Those Lordship, they are taking advantage of 4,52,000. But as per our calculation, it should be 99 lakhs 44,000. And we have already filed our affidavit and furthermore, Lordship.
The bank guarantee which was directed to be furnished by this court in the order dated 22/1/2026 at page paragraph 8
4,52,000
is what? How much? 4 lakh?
4,52,000.
It's 4 lakh 52,000. Now, how this figure was arrived at by the court?
Lordship, in earlier petition, the same amount was.
No. In the order itself, it is mentioned below. In the order passed by the respondent authority, the tax amount is mentioned to be this. Rest is penalty, my lord. Penalty and fine. This is the tax amount which has been determined.
Table we have.
No, let us see the order. See, you may be right in contention that the actual penalty is much higher. But that is now, what did the order reflect?
My lordship, you see page 128
Of the,
of the petition, the order which was passed. It starts from page 125. Lordship, can you see page 128? In the middle.
this is dated what?
This is dated.
Dated?
Just
22/12/2025. At 128, what is there at 128?
128, my lord.
Yes, what is there?
Calculation of the taxable value and tax.
Yes.
In the middle lossy fine. 2 lakh something is the CGST and 2 lakh something is the SGST. The total of that comes to 4 lakh something.
What's in that same order?
And I'm coming that the rest is the penalty and the fine. I'm not disputing that one. I'm saying about only about the tax amount. Lordship only inquired that where from the tax amount has come. So tax amount has come from this one.
What's it, page 129? Summary of pending fine. This is number 2. Same amount which has been quoted in here.
But this court has taken into consideration the tax which would be the subject matter of demand, which total is 452,076. Now, the entire matter is under adjudication. Now, if they are not successful, if they are not successful in this writ petition, in spite of the compliance of the interim order, the tax part is secured by way of bank guarantee. So far as the penalty is concerned, you can proceed against them. But if they are successful, if they fail in this writ petition, if they are successful in the writ petition, what is the necessity to furnish a bank guarantee of the penalty amount also? You may be right in contending that this 452,076 is the tax component, but there is also a penalty component, and the total would come to around more than 90 lakhs.
Yes, sir.
So the bank guarantee is not commensurate. It should be more.
Yes.
Because you are not perhaps on principle against the order of release of the goods.
Yes, sir.
You are only on the aspect of how much would be the bank guarantee for. Now the court in its order dated this 22/1/2026 has taken into account the tax component, both the state and the central. Ultimately, the amount has been quantified as 452 as per the order. The order has another component of penalty. Now, penalty will come when he fails in this petition.
Or even the tax amount.
Now, if he fails in this petition,
Certainly.
penalty will come, you can enforce the penalty. But you are secured so far as the tax component is concerned.
Even below the tax amount, 4 lakhs, whatever they will determine. I'm just not on
Yes.
this. So that has been determined on the basis of the market value and the judgments of this own.
No, Dr. Saraf, we are not even having any adjudication process
one
on
thing
the
I-
aspect of the
I
amount.
only want to.
Amount may also vary. We are not know. We are we are prima facie going whatever is the.
Whenever your lordship passes the interim order, my lord, generally lordship secures the tax amount. Because the tax amount ultimately, if the tax amount is not there, question of penalty will not arise, fine will not arise. But if the tax amount is secured, generally my lord, normally when the interim orders are passed, even the interest amount, the court is not asking for the interest amount, tax amount at least. That too also in lordship will passes order 50%, 25% on that way. Well, even the appeal when it is filed before the appellate authority, 10% of the tax is to be paid and balance is stayed. When the appeal is filed, my lord, by the department. Now here the entire tax amount of bank guarantee has been given. In my humble submission, that is, my lord, when the appeal itself is to be admitted on payment of 10%.
We can go for adjudication of this case, but you comply with the order.
No, no, see, we are not saying that we will not comply. Just we come for clarification whether this amount is.
No, we don't think that there is requirement of increasing the amount of the bank guarantee.
And Lordship, furthermore, there are other facts which may be considered by Lordship if we file our affidavit.
You have already filed the affidavit.
Number one thief. You want to say in the petition, I am number one thief. I am a biggest tax evader of the country, but that will not determine the transaction which is in question. You cannot say that a person is a thief, a person is a tax evader. So in all the cases, irrespective of that, you impose the tax.
Moreover, Lordship, the captain was shown the affidavit in support of the affidavit. He's also admitted that he's not aware about the function of the petition company.
That's what decided.
We have also annexed along with this statement, along with this IA as well as with the
Who is the deponent?
deponent is one. Abhishek Chhaja.
Abhishek, who is not connected with the company,
Yes, Lordship. He admitted in his statements given before the authority.
made before the.
Authority. Now
Where?
they may say that he is literally with the statement.
No, that will be
Well,
decided.
47, I am the local branch in charge. He's the branch in charge.
Lordship, not correct. He is admitted that he doesn't know about the affairs of the company.
Well, when the
Where?
Yes,
Yeah.
Lordship.
statements which are recorded by them, my lord, we have also seen the last summons. When the summons are issued, my lord, they just, I must say, don't want to say anything, my lord. How the statements are recorded, on
It's
what
page-
basis?
Page 80.
Of your IA,
IA.
80.
Question number 5. The director of the company, Mr. Chaudhary, he was arrested by the department laws. And he was initially granted bail by the London trial court, but it was cancelled by the High Court. And ultimately Supreme Court.
80. Which question?
Question number 5. Please state if the writ petition number so and so was filed by you on behalf of the SVLDRS Banijya. GST number so and so, number what you report. Sir, I am not aware about the writ petition number so and so filed by on behalf of SVLDRS Banijya in Gauhati High Court. In January 2026, Sri Shashi Kumar Chaudhary,
Who is Shashi Kumar Chaudhary?
he is the director of the company, of the petitioner company. Lordship, his bail was affirmed by, cancelled by this honorable court, and he went to Supreme Court. Supreme Court also ultimately affirmed the order of this honorable.
What order? Affirmed.
Yes, Lordship.
3 days only, he said
Yes.
that 3 days you remain in custody, thereafter investigate.
Yes, Lordship. Please to
And I understand that Supreme Court has said that, my lord, whatever in another case, the bail was granted, not granted. So many years, how many period has expired? They are still investigating, no notice. On the basis of their investigation, they are saying that he's a fraud, he's a thief. And come to the adjudication order, it will be decided.
And he was also arrested by West Bengal authorities.
Anybody can be arrested. You have got an ample power nowadays to arrest anybody.
And Mr. Shashi Chaudhary asked me to sign some papers. I was not aware of this related to the petition filed in the Gauhati High Court. I signed.
No, Mr. Mikhail, you may have a point because this Abhishek Chhajar is a 10 standard pass and he is a branch in charge. Something may crop up later on, but at this stage.
No, Lordship, I'm just.
No,
He
no,
has
we have
retracted-
seen his 10 standard.
My lord, he has retracted that I was in the force. I was made
But
to,
those retraction is okay, but his 10 standard pass.
my lord, this will be decided, your lordship.
That is it. But he may have a point later on.
He may
You may not have, you might not have noticed. First line. Branch in charge is 10 standard. Of a company of worth, how
my lord,
much?
for Supari, how much more branch? Supari, even fifth standard is sufficient.
No, no, you are a company of how many?
No, company, my lord, the
Company,
no,
the worth,
Supari-
company's worth will be in
my lord,
crores.
the branch in charge for what? Receiving the Supari, sending it. That is the branch in charge job. Not dealing with all those transactions, my lord. Your lordship is aware, my lord, the branch in charge is not necessary to be the MBA and the, my lord, B.
Lordship, just to support my submission, may not be related at this moment. But in my submission, Lordship, it is related, page 64, my kindly.
You are saying may not be related, then you are saying related.
Yes, because.
You have to make your stand very clear whether it's related or not related.
He
Yes,
he will only say, my lord, that he's a thief.
Yes,
He's a tax evader.
64.
Page 64,
Yes.
paragraph 61.
61.
Yes, but this order was passed by this honorable court, cancelling the bail of the petitioner.
Which petitioner? Shashi Chaudhary.
Yes, Lord.
In another case, my lord, not this case.
No, not this case. And this is related, we'll produce lots of proof that. In view of the aforesaid finding of this court, it is opinion that arrest of the respondent on 5/6/2025 cannot be termed as illegal or in violation of Mexico CGS State 2017 and BNSS 2023.
Or the Learned CJM had granted him bail.
Yes, Lord.
It was rejected.
Granting a bail that was.
That was cancelled by the.
And Lord, they went to Supreme Court also, page 66.
Interesting.
Page 69.
My lord, I will only submit one thing here. Whatever they are, there is no dispute. These are orders passed by this honorable court or the Supreme Court. My lord, in one case, a transaction, a person is under investigation, is arrested. A particular transaction is arrested. That investigation is still going on. Can it be said on the basis of that for future, whatever transactions are there, since he was arrested for once, thereby in all cases, it should be taken that no.
He's not heard the story of Ratnakar and Valmiki.
He became sadhu.
Let's see another thing. Here.
Did not know.
See the modus operandi.
She has become Valmiki now.
My lord, modus
After one
operandi,
arrest.
my lord, if he wants to say about the modus operandi, my lord, then I may be also granted the opportunity to say what is the modus operandi of the department. That I will also clarify.
Yes, Lord.
What is the modus operandi? It will be very painful.
Lord,
Modus operandi of he wants to say, I will also make full disclosure
yes,
of the modus operandi of the department, and that will be recorded.
Yes, Lord.
Yes, please do it on affidavit.
Yes,
We'll
Lord.
My lord, once he says that, my lord, what is the
please
modus
do it on
operandi?
affidavit. Seriously, we have to take.
Yes, Lord.
If there are in the procedural part,
My lord, one thing I will just prior to that. How many cases are coming before this honorable court challenging the search and seizure? How many cases are coming? Cases are not coming and will not come. And the reason that the cases are not coming is a very serious warning that something wrong is going on. And that's something wrong, which I earlier also I submitted for lordship, mediation. Something wrong which is going on. Search and seizure, the lordship thinks that, my lord, the search and seizure, wherever they go, nobody is aggrieved. Persons are aggrieved. But, my lord, your lordship must have heard the story. There was a story that, my lord, the one roti was there, half, 1/4. In this way, my lord, the distribution was there. That roti is being distributed. And one who doesn't agree with the distribution, that matters are coming before this honorable court. If you, my learned wants to hear anything more, then you can show that what is going on.
You bring this on record, put the name
My
of
lord, the
the,
person concerned.
put
who
the
is
names of the personnel here, we'll
my
see
lord,
what we'll
person
do.
concerned must also here to carry on the business.
You're
They
correct?
will tomorrow, my lord, I personally can make submissions. But the person concerned who is carrying on the business, that is the disadvantage, my lord. That is the difficulty which is going on. In every case, well, they will show 50 lakhs recovered. So much recovered. My lord, is it 50 lakhs recovered? It is 50 lakhs recovered. Don't allow me, don't force me to make the submissions.
Lordship,
Otherwise, it will be difficulty.
not Lordship, we are.
The case which has come up before Lordship, my lord, which is going on summons
6 times.
6 times. Their only reason is that the settled amount has not been paid. That is the only reason. There is no other reason.
Lordship,
Put it on
Tomorrow the case.
Ask your client to put it on affidavit.
My lord,
See what we'll do.
My lord, that is the, my lord, the most, I can say that the difficulty of this country. The problem before this country is that, my lord, the people, they are so scared of these people that they will not, because they have got
Mr.
the
Kyle
power.
doesn't appear to be so dangerous looking.
You know, Mr. Kyal is very nice.
He's very docile.
No, he's very nice. I am also not bad, my lord, like, in looking into it, my lord.
No, you're better.
My lord. But the problem is that the person who are giving instructions, they are very dangerous, my lord. They are very, very dangerous.
And Kyle is controlling those dangerous people.
Yeah, it is duty, my lord. As
So how dangerous?
As I am defending my client.
How dangerous he
My lord, as I am defending my client, which he says that tax evader, thief, decade, and all those things. My lord, we are doing our duty, my lord.
Lordship, what happened? This submission was made before Honorable Supreme Court, and in Ratika Agarwal's case, Supreme Court in paragraph, I forgot the paragraph, clearly stated that if such type of things are there, they should come before the court. The court
That's
is-
why, my lord, we have come, my lord. 3 crores rupees were collected forcefully at the time of, my lord, investigation, and we have come up before this on the court by way of writ petition for refund. This is not the, my lord, the time to make all the submissions. A time will come where all these submissions will be made, my lord.
I think Radhika, you're referring to paragraph 56. Paragraph 56 of
My
Radhika.
lord said, my lord, that if some allegations are there that somebody has forcefully collected the tax
Yes.
at the time of investigation, I am not saying of tax. Radhika has not dealt with the something which is other than tax.
Here in this case, Lordship, the petition, director of the company, Procedural, his conduct has placed before a law.
He is thief.
His conduct has been placed before a law, and we have stated.
No, he is a big thief. He is a big tax evader. So many cases are there, my lord, against them.
In this case, Lordship, the bill is not.
Okay, let us come back to the issue.
This was only because my Thursday, my lord. So some time was there. So otherwise, we would not have said, my lord, taken your lordship's time.
You have time, we do not have time, even on Thursdays.
Well, Thursday, today, the matters are little less. Your lordship is little.
Matters are less in the court, matters are more in the chamber.
Chamber, your lordship.
Matters are more in the
In the
chambers.
chamber, my lord, your lordship has a lot of things to be done.
Okay, we are not inclined to, Mr. Kyle, we are not inclined to vacate the order.
No, we are not praying for vacating.
Vacating, we are not inclined to modify to the extent of increasing the amount of bank guarantee.
Well, your lordship, for
Because this court, a coordinate bench had applied mind and looked into the aspect, what is the amount involved in the tax component, and that same document also had the component of penalty. In spite of that, it is the tax component which has been included in the bank guarantee. And we also think that that would be a balancing of equities that has been
your
done.
lordship has record for his interest.
Definitely.
In case the petitioner loses in the writ petition, he shall be liable. I will undertake that if he shall pay.
No, why should we say that?
No, no.
Otherwise also they'll be
No, for his
they'll be entitled for the entire thing
for his satisfaction.
Not page 90 may can be.
of your IA.
No, for requisition.
90. Yes.
Not a tax invoice. This is a delivery note.
Delivery note, yes.
Which is not a valid document under GST.
No.
Quantity is 21,000 K.
I will show it is not a valid document.
Yes.
Okay.
But this delivery note was issued by you.
No, no.
Who had issued this?
The Repeat is none.
Huh?
It is not supported by any UAB.
UAB is not required.
Oh, this is the petitioner's document. They are the signatories.
Yes, sir.
You're correct. But nonetheless, okay. Have you filed your affidavit?
Yes, sir.
We'll file a reply within.
Okay.
Mm.
Just file.
It will also be in the record.
If you agree, we can have this main writ petition without passing any orders in this. But the aspect of facing a proceeding by you would be open. Will not say anything.
No, that is already, probably they have submitted the reply also.
No. With regard to the compliance of the interim order.
Lordship, what about Lordship directly?
At present, Miller, your
No,
lordship.
no, what we are contemplating that instead of passing an order in the IA, you have filed an IA for modification. We are not saying anything, but we have got a feel of the matter. We can have the entire writ petition for hearing immediately on the filing of rejoinder.
Well, only thing, but not unless and until your lordship passes some other IA, they will not release it.
You file contempt against them?
Well, if your IA has been filed, they will spending, your lordship may just, Lord, because he is saying that I'm not pressing for the vacating and all those things. Your lordship may say that in the meantime, matter will be heard. IA will not be considered.
Third, 3, SC Kyle, Leonard, Standing Council, CGST.
Lordship, in this case, DGGI. DGGI.
DGGI. What is DGGI?
Director
Director General of Goods and Services Tax.
Intelligence.
DGGST.
DGGI.
I.
Lordship.
Okay. Director General of Goods and Service Tax Intelligence.
Lordship.
Correct? DGGI. For the applicant, also heard Dr. A. Saraf, London Senior Counsel, assisted by Sri A. Kaushik for the opposite party writ petitioner.
Although his name may also be mentioned.
Okay.
B. Sharma.
B. Sharma. Duta Nama. By the instant application, modification, cancellation of the order dated 22/1/2026, passed in the connected writ petition dated number in this prayer for modification so and so against the order dated so and so passed in WPC so and so has been made. Full stop. Para. By the aforesaid order dated 22/1/2026, this court, while issuing notice, had notice was not issued or what?
Notice was issued. Notice issued.
No, don't say it. Notice was not issued. This court, kya bola? This court had passed an interim direction providing that subject to furnishing of adequate bank guarantee before the respond number 2 to cover the demand of tax short paid, namely rupees 2,26,038 respectively for CGST and SGST, totaling rupees 4,52,076 by the petitioner, the consignment of the Areca nuts along with the vehicle numbers so and so, page 25, likh lijiye, be released forthwith. Full stop. The primary ground of filing this application is that while passing such interim order, the court had taken into consideration only the amount of tax short paid and not the penalty involved. By drawing the attention of this court to where is that document into which indicates the penalty?
In the same 120 month?
128.
128.
Oh no, in the IE.
No, it's 98.
IA में कितना है?
uh, drawing the attention of this court to the order dated, is it 22/12, 2025? 22/12, 2025,
Page 129, the details.
22/12, 2025, comma, it were issued by the director, what? the-
Assistant Director.
Assistant Director, it will say. He has submitted that the same would indicate that there is a component of penalty and the total amount would be 99.
My lord, at page
Nine-
129.
99,45,656. Full stop. He accordingly submits that to balance the equities and secure the ends of justice, the amount of the bank guarantee should be increased proportionately. Full stop. He has submitted that in principle, he is not opposed to the aspect of releasing of the goods which are admittedly perishable in nature. Full stop. Para. Dr. Saraf, the learned senior counsel for the opposite party writ petitioner, has however submitted that while passing the interim direction on 22/1/2026, this court was apprised of the penalty component, which clearly appears from Annexure
10 million.
Annexure 10 of the writ petition, which is the communication dated 22/12/2025. Full stop. After such consideration, to secure the amount of tax involved, the aforesaid, the present interim order has been passed to directing furnishing of a bank guarantee of an amount equivalent to the tax allegedly short paid. Full stop. He has also informed that in the pretext of filing the IA, the interim order which was passed inter parte has not been complied with till date. Correct? Full stop. Para. Upon hearing the learned counsel for the parties, this court has observed that while passing the interim order dated 22/1/2026, this court had taken into consideration the amount of tax short paid, which is rupees 4,52,076. Full stop. Though the annexure, this court has also noted that Annexure 10 to the writ petition, which contains the calculation in tabular form, also constitutes the penalty amount. Full stop. In the considered opinion of this court, the primary purpose is to secure the amount which is amount of tax short paid as alleged by the department. Full stop. Accordingly, this court is of the opinion that the interest of justice has been taken into consideration, and on being prima facie satisfied, the interim order has been passed, more so when the goods involved are admittedly of perishable nature. This court is accordingly of the opinion that no case for modification of the alteration of the interim order is made out. Full stop. It is, however, made clear that the interim order passed, however, made clear that it is needless to state that in the event the petitioner fails in the petition, the department will have all the rights to enforce the penalty aspect.
In case the petition succeeds,
Succeeds to
then
succeeds, nothing will be there.
the interest must be paid.
Huh?
On the bank guarantee also the interest must be paid. Your lordship has secured the interest to the revenue. The interest to the petitioner must be secured.
The department is very poor, Mr. Saraf.
No,
Let us,
poor, my
let
lord.
us, let
That's
us, let us protect the department.
My lord, that's why I said
Yes,
not,
yes.
not poor, my lord.
They have to
They are very poor.
submit, they have to submit bank guarantee before responding number 3.
Three only is
We
written.
will comply.
No,
Huh?
2.
At this stage,
Huh?
three,
What the addition? It has no
Three.
addition.
No, no.
Kyle, the learned counsel has submitted that the bank guarantee is actually required to be submitted before the respondent number three
Respond number.
named designation.
Additional director. General of
My lord,
DCA.
earlier, my lord, your lordship may see earlier order.
No,
The-
let us clarify.
Otherwise, the bank guarantee has been prepared, my lord. It was directed to be prepared after consult.
But see, we have already intimated to the petitioner through email.
Is it difficult? I don't think it's difficult.
Whatever they come, my lord, since your lordship, my lord, I will not fight on all this.
But at this stage, Sri Kyle, the learned counsel, learned standing counsel has submitted that the bank guarantee should be in the name of the respondent number 3, namely the
Additional Director General of GST Intelligence. DCG.
respondent number 3. Full stop. The petitioner is accordingly the interim order dated 22/1/2026 is accordingly modified to the extent that the bank guarantee be furnished in the name of the respondent number 3 instead of the respondent number 2.
The desire of Mr. Kiali is a
Ah.
command for us.
Then in the writ petition, what do you write? In the writ petition, you write
Time for
the I dated 7/05/2026 for vacation of the interim order dated 22/1/2026 has been dismissed today. Full stop. Sri S.C. Kyle, learned standing counsel has submitted that affidavit in opposition has already been filed. Para. Dr. A. Saraf, learned senior counsel for the petitioner, prays for some time to file the rejoinder affidavit. Let such rejoinder affidavit be filed within a period of 2 weeks.
3 weeks, let it come after due vacation, my lord, because matter ultimately. If all the matters are finished, my lord, there will no occasion to come before your lordship.
Don't say this in public, but you are already in public domain.
My lord, public domain, but if some
If
matters may remain, my lord. 25, there are matters all that may be disposed of first.
What is the pendency, Mr. Saraf?
My lord,
Are
that
you
is
aware?
not- my lord, that is not the, my lord, the earlier matters which are there pendency. They are in fact your lordship is disposing of daily.
Similar matter is fixed on 23rd of this month.
23rd may not be
no.
adequate time.
Just
Okay, place for list this matter on 21st of April for admission, prior to which further pleadings are to be exchanged. Yes.
I'm highly obliged, my lord.
Yes, what is this
My
information?
lord, here one a showcase was issued to the petitioner on 20.
Turn on pani and everything.
My lord,
Can dispose this off
the general affidavit just for some time it will given to.
today. So we can have it on Tuesday next.
my lord.
We'll dispose it of. What is the issue involved?
One first showcase was issued. There was culminated in order in favor of the petitioner. Another showcase was issued. An order was.
Oh, you
passed
said
against-
that principles of
Yes,
res judicata would apply.
Same figure, same fact, same allegation. Issuing authority was same, my lord.
No, can you do it, Mr. Kyle?
Tuesday.
But otherwise, if it is adjudicated, it cannot be to the unending process until you desire a result of your choice.
My desire is not important. So will be.
No. You means not Mr. Kyle. You means the department. Department. This is what the expression has been used in judicial pronouncements. You go to an in an unending process until you get your desired objective.
If that is their lordship, then I'll concede on Tuesday. If that is so. I'll go through.
If there are any other materials, we may still adjudicate, but if it's on the same facts, same materials,
Affidavit is on record. I'll go through and if it is.
because this is the general principles which are applied in all cases, even in disciplinary proceedings. We have found that enquiry is done, ends up in a report favorable to the delinquent, then another enquiry, not permitted.
That is so, then lots of times we have noticed, but since we have affidavit.
Okay,
Go to the
okay.
document.
Oh, heard Sri R. S. Mishra, learned counsel for the petitioner. Also heard Sri S. C. Kyle, learned CGST.
Okay.
CGST, full stop. Sri Kyle, the learned CGST has however submitted that the rejoinder affidavit of the petitioner has been filed, has been served, that a copy of the rejoinder affidavit of the filed by the petitioner has been served only today. Full stop. He accordingly prays for some time to obtain necessary instructions. Para, as agreed to by the learned counsel for the parties, list for admission hearing on Tuesday next.
There is an interim order, madam.
Interim order passed earlier to continue till the next date of listing.
Nothing more.
Item 12 and 13. Twelve and 13, what is it?
In this case, my lord, the petitioner's lordship, the predecessor of the petitioner's lordship were refused his lordship. In 1959 lordship, the land was allotted lordship as refused his lordship, loan was granted to pay the premium lordship. Accordingly, the premium was paid lordship. Now subsequently, the patta was not granted, final patta was not granted. The, my lord, refugee committee, my lord, at Bangladesh district, was pursuing the matter, my lord. Ultimately, a proposal was, my lord, submitted in 2015 lordship. That is at page lordship 57 lordship. In this proposal, lordship, we were again directed to my lord to submit my lord deposit the premium, lord, that is of too high lordship.
How much is the premium?
It is 8 lakhs. 8 lakhs. Sorry, lordship. 8 lakhs 50,000 lordship.
How much is the area?
My lord, earlier paid lordship. The entire my lord value cost of the land was paid lordship. The my lord.
Mr. Ravindra?
He did not serve us
It's-
copy, therefore he could not communicate.
My lord, it was served earlier lordship.
Lordship, this premium, so far as I know, there is a notification of fixing a premium. There has been fixed from the notification.
Have you filed your affidavit?
No,
What is the other case? Requirement?
Other same my lord, similar lordship, other petitioners lordship.
In that case also affidavit not filed.
No lordship. No, my lord, in 2017 lordship, my lord, representation for reconsideration was submitted lordship. That was not disposed of, my lord, then replied.
You have your instructions.
no, I can call lordship and directly.
You filed the affidavit, but these are matters of 2023 pending. since
Lordship.
2023. You have already taken almost 3 years. Why instructions are not there?
Not there because that was not communicated again. Probably service copies were not.
They're not
My lord, it
given.
was my lord, served lordship. I don't know whether my lord,
It's not there in the file.
my lord steps here taken lordship. Probably different council was there, lordship, Mr. Mr. P.T. Mahanta. Received of. SC Revenue Lord.
But last order said Mr. Ali, your colleague,
Lordship.
learned counsel has submitted before this court that he would communicate with the learned counsel for the petitioner to ensure that extra copies of the writ petition is furnished to the learned counsel appearing for the revenue department within a period of 1 week from today. Revenue Department thereafter filed their affidavit in opposition in 3 weeks. Now, was it filed?
Yeah.
Hmm. Now, have you received the extra copies? Or you have communicated? Mr. Taludar, you kindly coordinate with Madam Mohanta? Because you are communicating with whom? I think
Because fixing revenue.
yes, yes. We are only concerned as to whether the instructions from the appropriate authority comes, whether it comes to you or her, will not make any difference. Madam, how soon can you get the of which one? Which read? 5224. 4. Page 68. Yes, madam.
68 is the wallet.
Regarding has any rate been prescribed? %. You file your, you get your instructions, okay? Hard free Ahmed, Learned M.H. Ahmed, Learned Counsel for the petitioners in these 2 cases. Full stop. The grievance is with regard to the aspect of premium which is required to be paid for settlement.
Resettlement loss.
For resettlement of the land. Full stop. It is contended that the premium is exorbitant. Full stop. Para. Though this writ petition is pending since the year 2023, due to late furnishing, due to the delay in furnishing extra copies, the instructions are yet to be obtained. Full stop. Ms. P.R. Mohanta, Learned Standing Counsel Revenue, has, however, submitted that she is expecting the instructions shortly, as the matter was communicated after the last order of this court. Para, in that view of the matter, in view of the aforesaid development, matters are adjourned to be listed on yes, when 21st of April. You get enough time. Okay, you get instructions. We try to dispose this off.
Well, apart from the premium is very high lordship. Their grievances, my lord, is at the already it was paid.
Pay.
Rupees 154.
And in spite further, it has further been contended that the premium which was calculated earlier was already paid.
Already paid rupees 154 loss. 154 in 19 60s.
154 for settlement.
My lord, at that time it was high lordship. 1960s lordship, it is my lord 154. Cost of the land lordship.
We have serious doubts. Where is the land?
Moigaon town lordship.
Moigaon is very expensive.
My lord, at that madam, my lord, undivided Gwalpara was there lordship.
It was more expensive then.
Anyway, lordship, it was paid lordship at that.
Okay,
moment,
well, let us see this. Let us see this aspect.
Okay.
Okay, next.
14.
I'm standing on behalf of SK Singh, my lord. Or has applied for online. I'm standing on behalf of Senior Counsel SK Singh.
Yes, Mr. Singh. Yes, Mr. Singh, what is this?
My lord,
Yes, what is your case?
My case, my lord, is very simple. My name was there against a holding, municipal holding, my lord. It earlier existed in the name of my father. Subsequently, it was transferred to the name of my mother after death of my father. And later on, after death of my mother, it was transferred in my name. All of a sudden, my lord, I found that the holding has been transferred in the name of respondent number 4.
Who is R4?
R4 is a private individual, my lord. Now, R4 claims, my lord, R4 claims that I have executed an unregistered sale deed in his favor. And on the strength of unregistered sale deed, he approached the municipal authority and they have transferred the municipal holding in his name. My prayer was very simple before the Tezpur Municipal Board to restore my name until and unless the controversial dispute is resolved. Until then, I may be permitted to tender the taxes because municipal holding doesn't confer any title. My only objective was to restore my name so that I can pay the taxes. When the municipal authority did not adjudicate, I had to approach this Honorable High Court on a previous round of litigation, and that was disposed of with a direction that the municipal authority would consider my representation and then will decide. The municipal authority, my lord, relied on the unregistered sale deed and said that we have done it correctly, nothing doing more than that. Now that is the bone of contention. My simple prayer, my lord, is that if restoration is allowed, I will be only entitled to pay the taxes. Rest of the dispute cannot be adjudicated before this Honorable High Court. Naturally,
Who is in possession? Who is in possession of the property?
my lord,
Who is in possession of the property?
myself, my lord, and that has been given.
You are in
Myself.
possession of the holding. Holding
Petitioner.
pertains to a property, a house or what?
It pertains to a house, and the land actually belongs to the municipal authority. It's a reclaimed land, my lord. As your lordship knows, reclaimed means the river Brahmaputra left some soil, my lord, which got settled down. And this land has become a reclaimed land, which has been allotted to different persons. I have constructed the house. So ownership of the land is a reclaimed land, my lord. It's a patta land, but reclaimed.
You say that you are in possession.
My lord. And that has been admitted by respondent number 4 in their affidavit, my lord.
Who's
May I
for
take your
R4?
lordship to
You're for R4.
Yes, Your Worship. I'm respondent number 4.
Who is for the municipal board?
File an affidavit, my lord, but
Who's appearing? Somebody appearing?
my lord.
In
Mr.
other
Lee?
occasion, someone used to appear. Your Worship.
Is it Sundi who was appearing earlier for municipal
My-
board?
let me check.
Mr. Hussain, you are for R4.
Yes, Your Worship. Now,
What do you say?
Now, the petitioner has said, Your Worship, that the petitioner is in possession. I don't agree to that, Your Worship. I'm in possession. I have stated in my affidavit, Your Worship. They have.
Are you paying the taxes?
Yes, Your Worship. I've annexed it, Your Worship. And now, in the earlier occasion, Your Worship, this honorable court has sought direction from the municipality to ascertain who is in possession. So, this would have been here, Your Worship. But Your Worship, if Your Lordship peruse the.
But can you get immovable property transferred by an unregistered deed?
Your Worship, the thing is, Your Worship, the conduct of the petition, Your Worship, I am not the first person. It is his habit. He used to take some consideration. He used to execute a deed and he used to transfer. Now, Your Worship, he has provided an NOC also, along with the deed of agreement, that he has nothing to say that if the holding number is being transferred to my name, Your Worship. And if Your Lordship.
Now, Mr. Singh, if the taxes are being paid up to date, whether you are paying or Mr. Hussain is paying, you say that you are in possession. Hussain says that he is in possession, but the important part is that the up-to-date taxes are being paid.
municipal taxes, since my lord, he has
Are
got
being
the
paid because
holding in
Mr.
his
Hussain
name,
has
R4.
Produce certain documents of payment receipt. So there
Because-
will be the question of default will not come. We can decide the entire case. What is your main prayer?
my prayer is only for restoration of municipal holding in my name so that I can pay the taxes, my lord. I am not saying that whether he is paying, because since the name is in the holding is in his name, definitely he may have the right to pay the taxes.
So we
But
will have to
on
see
what-
as to what was the relevant consideration which propelled
Unregistered sale deed, my lord.
municipal corporation to make the authorization.
Unregistered sale deed, my lord.
Yes, if it's the unregistered sale deed, perhaps it cannot. That is, the law is very clear. It's a immovable property. How could you change the holding?
Lordship, once they have approached this, to your lordship,
Yes.
has demanded this matter to the principal.
Yes, that Mr. Singh has already contended, yes.
Decide with your lordship. If your lordship tells the order, your lordship, it will be clear, your
Let
lordship.
us see the decision of the municipal board.
Yes, your lordship, it starts from page 38.
My
30.
lord, may I request my learned brother to remove his file from the microphone because he is not audible to me.
Sorry,
My brother,
I'm very sorry.
so
there's
that
no
I can
microphone
listen
here.
him.
There is no microphone here.
No,
I'm
that-
using another piece here.
No, that is your microphone.
Yes,
that-
your lord. It is near me. Now, if your lordship may peruse from page
38.
9, para 10. That you along with your mother, page 39, para 10.
Yes, Riz.
Para 10.
You means
You
The
is the
petition-
petitioner.
petitioner, Anupam Ghosh.
You along with your mother, Savita Ghosh, after the death of your father, executed one agreement by serial number so and so for the year 2019, executed on so and so in favor of one Ruby Paul, wife of Cecil Paul, for cancellation of agreement dated 17/9/2018. So before they had executed another agreement.
Mm.
Now, point number 11, that as per the said agreement dated so and so, it is clearly stated that the said holding number 85 was transferred to said Ruby Paul.
Hmm.
And thereafter said Ruby Paul.
What is your name? What is your name?
I am Ram Sahan.
Ram?
Sahan. Ramchandra Sahan,
Okay.
your lordship. So this has been going on, your lordship. The transfer the said holding number 85 to your mother, Savita Ghosh. Then it was again your lordship.
No, Mr. Hussain, there will be two aspects.
Yes, sir.
One is the de facto aspect, one is the de jure aspect.
Lordship.
De facto, he must have taken some consideration
Yes, sir, lordship.
and an agreement. But will it be enough in law to change a holding? What is the law which is governing the aspect of change of holdings? Can it be done by a registered sale, unregistered sale deed? That is the question. You assist the court will answer it. Mr. Singh,
My
on the
lord,
basis of unregistered deed, can a holding
it cannot
what
be,
is
my
the-
lord.
How
It can't
how a
be.
holding is altered, mutated?
My lord, the ownership has to transfer, and ownership can transfer only by way of a registered sale deed. What has happened, my lord?
No,
The-
Mr. Singh, there are instances where a separate holding is also given to certain tenant. Tenant doesn't become the owner of the property,
My
but
lord,
it is on the basis of some NOC. That I
Yes,
do not have any objection as a landlord if a different holding is granted in the name of the tenant.
that
So
can be
holding
done,
that way does not require a per se transfer of ownership.
my lord.
So
But
in
in
that
my case,
consideration, we are just otherwise unregistered deed, we would not have given any cognizance. But
My
here
lord-
is not a change of ownership, it's
My
only a change of the holding.
Holding.
Whether it can be done on the basis of an unregistered deed, that is the
Here-
question.
yes, my lord. Here in my case, it is because of the transfer that has got his holding in his name, my lord, because of change of ownership. Now the change of ownership has been done on the strength of a unregistered sale deed, which is at page 54, my lord, annexed by R4.
Reported your lordship.
Page 54, my lord.
53 to your lordship. That is the NOC, your lordship. Page 53, and thereafter the page 54 is the deed of agreement. Deed of sale. Deed of sale.
What about page 53, Mr. thing. 53, in clear terms, you have given an affidavit that I do not have any objection. This is no objection.
My lord, in this regard, we have disputed. My lord, may I take the assistance of Priyanku there?
Yes.
Because what has happened, my lord, in this case, my actual junior was Banibrat Pusilal. He expired last
Okay,
year.
okay. Yes,
So I had to restructure the entire brief, my lord. So many parts I am missing. 53 I do have, but we had filed one rejoinder. Priyanku can help whether that is there. Or else I have to verify, my lord.
Rejoinder is, no, rejoinder is not there.
It's not there.
I've also not received it.
It's not there. When did you file rejoinder?
My lord, that is what the entire brief I could not restructure. I am in the process, my lord. And
But
one
it's-
thing
it's not even in
more
the
that
court
I have,
records. It
one
is not
more
even in the
thing.
court records. If it had it been the court records, you would have got a copy,
My lord.
got it restructured. It's
But
not in
as
the
per the
court.
last order, what I have seen, my lord, there is an order that, my lord, the time has been granted to file reply to the affidavit in opposition, my lord. So I don't think, my lord,
It might not have been
my
filed
lord have been filed, my lord.
because that was on 31/10/2025.
My lord.
And he died
The
next
order
month.
was that 3 weeks, by which time petitioner may file response to the affidavit in opposition.
My
He
lord,
had to
then
file a rejoinder.
within 3 weeks he died, my junior. Thereafter. So
That we know, but that's very unfortunate. But whether it was filed, we don't think it was filed.
my lord, kindly
you want
give
to
me
file
some
a- if
time
you
so
want
that
to-
I can verify.
If you want to rejoin, you can rejoin by filing an affidavit.
My
You
lord,
can
I will do
grant
that.
some
My-
time. Okay. Heard. 3 SK Singh, London Senior Counsel, appearing online along with 3 peacefully for the petitioner who is present. Full stop. Also heard 3 BJ Talukdar, learned additional senior advocate, as well as 3 I Hussain, learned counsel for the respondent number 4. Full stop. Para. 3 Singh, the learned counsel, has informed that the advocate on record had passed away and therefore there is some communication gap with regard to the aspect as to whether rejoinder affidavit
Has
was
been
filed or not pursuant to the order dated 31/10/2025. Full stop. He accordingly prays for some time to take appropriate steps in this regard. Para. Well, how much time?
2 weeks is sufficient.
List on, we give a date. List on list on 2nd of April. Is it okay?
My
2nd
lord.
April.
My
You get
lord,
sufficient time if you
My lord.
if you find that you have not filed the rejoinder, you can file the
My-
rejoinder.
Much obliged.
obliged.
Item 19.
May it please your lordship. Lordship, affidavit was supposed to file by the respondent lordship in this case.
This matter, Lordship, we have missed the file. Lordship, this matter, we have missed the file, Your Lordship. It's not traceable, Your Lordship.
Affidavit filed or not? Not filed. You reconstruct your file, madam.
Yes.
It's not something new. Get it from the court's record. Do whatever is required and file. Have we got the instructions? Yes. Okay. Those 3 and Pathak,
Yes,
learned
lordship.
counsel for the petitioner is present, comma. Ms. Ann Bodoler, understanding counsel revenue department has submitted that the file is not readily traceable. Full stop. See accordingly prays for some time to reconstruct the same. Full stop. Matter accordingly stands adjourned. What is the IFR?
No, your lordship.
Is item 90. 90.
In this present case, no, I is your lordship.
Huh? Oh. Itu Hadira. Itu IS.
7573.
Itu কি?
Attend Beba.
Itu কি? Okay. কি করে রাস্তাটা? Adjourned. List on
3 weeks, sir.
list on
So 4 weeks, Your Lordship. if I may.
23 matter, we cannot afford 4 weeks. List on 2nd of April.
Let's.
Measure.
Madam, you have a look at the court records and whatever you want to do, you do. And Mr. Pathak, help furnish a copy if they are.
Yes, yes, by,
Requested
by tomorrow I shall.
measure.
22.
My lord, kindly peruse the last order.
Where is Mr. Dotto was there? Yes, Dotto.
My lord, for the
Where is he?
municipality.
Where is he, Mr. Dotto? That G+1 structure. Yes, you are for whom, Biswas?
My lord, I am for decimal number 4, the
Yes.
landowner.
Yes.
Here one development has taken place. The decimal number 4 has died on 6/2/2025.
6/2/25.
Yes. So I've been informed yesterday because I was not in contact with the main person because he died last year. And his sons were also not aware. So I somehow tried to contact and communication has been.
Then you have to inform Mr. Sharma. We take today's date, there will be no abatement because he is not aware.
No.
Under 11A, what is the section? CPC comes from. What is it? Rule 11A.
Order 22.
Rule 11A.
11 parts.
Is 11 or 11A? Or 10A? 10A, 10A. 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 Duty of the pleader to communicate to court death of a party. Okay. Yes, madam. Okay. The R4 has passed away. Are you aware? Mr. Doctor, there is some development. R4 has passed away. Mr. Biswas has informed. Since Mr. Sharma was not aware, by following the principles of 10A of Rule Order 22, Rule 10A, we'll take today's date as the date of informing the court, and he'll give the details of the legal errors.
Right.
You can get them, those included, because this is a continuing cause of action, and they have to be given a chance to defend the case. Okay. Heard Sri H.K. Sharma, learned counsel for the petitioner. Also heard Sri S. Datta, learned senior counsel assisted by Ms. S. Musari, learned counsel representing the Silchar Municipal Board. Full stop.
Corporation.
Silchar Municipal
Corporation.
Corporation. I got board like corporation. Which now corporation? Episode corporation. You are S. Biswas. Sri S. Biswas, learned counsel, appearing for the respondent number 4, has however informed that as per instructions received, his client had passed away on 25/6/2025, and this information was transmitted to him only yesterday. Put stop. Para. let the details of the legal errors of the aspect number 4 be furnished to Sri Sharma by Sri Biswas, whereafter appropriate application for substitution be filed as the cause of action would continue against the interest of the aspect number 4. Full stop. List immediately after filing of the IA for implement, for substitution.
Apply.
You have a details, Mr. Biswas?
I have details.
Yeah, give it to him, the names, who are the daughters, sons. Okay. And in the meantime, we also try to informally take the instructions that whether on the part of your appearance on their behalf. In that case, the aspect of issuing fresh notice can be dispensed with.
May I approve, Lordship? Lordship, as per impugn order, at page 31, there were few measures that was directed to us to be implemented. So accordingly, we implemented that measure 2, 3, 4. The main issue was that some local public raised a complaint regarding our sewage disposal system of piggery farm. So in meanwhile, we have implanted a biogas unit of that sewage of the farm. So Lordship, mainly we were agreed with the measure number 1, that is complete evacuation of animals. So if that measure is undertaken, that it does mean that we totally shut down we have to shut down our farm.
Where is the impugn order?
Impugn order at page 31.
3-1.
3-1.
Yes, 29/3/2023.
Yes, Lordship. That the 4-point measures were directed to be taken by DC Nolbari.
Yes, Madam, you are for the veterinary department.
I'm for the veterinary department, Lordship, on the.
Deputy Commissioner. How is it possible? Complete evacuation. No, if they have taken adequate steps.
Yes, Lordship.
Lordship, as per report, Lordship, there was a joint report, Lordship. Report was also annexed to our activity.
Respondent 3.
There would be some SOP for running such piggery farm.
That was veterinary department.
Madam, there would be some standard procedure for running. Yes, yes.
The last occasion, Deputy Commissioner was directed to sign there.
A file already. Now, if there is no scope of, see, it is contradictory. You are allowed to have a piggery farm, and there is a complete direction for complete evacuation.
One is contradictory to 2, 3, and 4 and 3. Only 2 days time I will. Instructions.
Now, how do you reconcile this? Mr. Roy, you may have a good ground of passing such orders, but this will not bring an end to the.
Lordship.
You have to find a solution.
That's why, Lordship, that veterinary department, they are the.
Now, what is the present state, Mr. Bathak?
Lordship, my humble submission is that their affidavit is of 2000.
No, what is the present stage? Are you running or not?
Lordship, I have few recent photographs.
You're running or not?
Yes, we are running because we have.
Because there is interim protection.
There is an interim order.
Yes, Your Lordship.
In that case, we can make the interim order absolute. We can direct that whatever standard procedures are there,
Yes,
he is duty bound to follow those.
Lordship, that's why, Lordship, my friend, to what is the standard procedure? We will inform this court, Lordship, on that we will.
we are implementing all the 3 measures, Lordship, as directed in the impugn order. 2, 3, 4, we have implemented. Only we are agreed with the one. Complete
If 2,
evacuation
3
of,
and 4 are being, then we comply, then we
Yes,
can
Lordship.
close this, we close this then.
yes, Lordship.
Okay. Heard 3M Pathak, Learned Counsel for the petitioner. Also heard 3SS, Dr. Goswami, you are for whom? You had lodged the complaint.
Yes.
Yes, Lordship.
Now what is the stage? Has it been resolved? Petitioner? Not done anything. The problem still subsists. No animal.
No, Lordship, there is animal, Lordship.
No, if he says no animal, there is no complaint then, that means. Are you aggrieved with him any action now? No. Okay.
So if you can take the farm.
If the farm is running, you are abiding by 2, 3 and 4, you abide by 2, 3
Yes,
and 4.
Lordship.
Heard 3M Pathak Learned Counsel for the petitioner. Also heard 3SS Royal Learned State Council, semicolon, Miss M. Kotoki, Learned Standing Council, Veterinary and Animal Husbandry Department, and Dr. P.K. Goswami, Learned Counsel for the respondables. 8, 9, 10. Mr. Talukdar, you also have cooperative, no. Okay. Sir, considering the facts and circumstances and as agreed to by the Learned Counsel for the parties, the instant writ petition is taken up for disposal at the admission stage. Instant writ petition, which is pending since the year 2023, is taken up for disposal at the admission stage. Full stop. Para. The petitioner is a partnership firm established in the year 2018 and deals with breeding, rearing, and selling of pigs. Fruits of the piggery farm is situated at village number 1, Kaplabori, in the district of Nalbari, and it is projected that it imports high quality breeding pigs from other states of the country. Full stop. However, at the instigation of some miscreants of the village, false allegations were leveled against the petitioner regarding on the issue of sewage, with the further allegation that foul smell was emitted from the farm of the petitioner. Full stop. Further, on 28/3/2023, the respondent numbers 8, 9, and 10 had led mob violence and vandalized the farm property. Full stop. The same was, however, followed by the impugned order dated 29/3/2023, issued by the District Commissioner, Nalbari, whereby certain directions, including complete evacuation of the animals, were issued. Full stop. Being aggrieved, the present petition has been filed. Full stop. Sri Pathak, the Learned Counsel for the petitioner, has informed at the outset that while issuing notice wide order dated 24/5/2023, an interim order was passed and based upon the same, comma, the petitioner is running the business. He has also submitted that he has also submitted that though the jurisdiction of the district commissioner to issue such an order is questioned, comma, the directions against serial numbers 2, 3, and 4 have been duly complied with. Full stop. It is submitted that the first direction for evacuating all the animals is absolutely unreasonable and will not amount to bringing in a solution of the problem, which was in fact created by some miscreants. Full stop. Para. 3. S.S. Roy, the Learned State Council, has submitted that the impugned order appears to have been passed in the interest of public. Full stop. He has, however, submitted that the first direction may not be construed to be a measure to bring in a lasting solution to the aspect, as the business as such has not been declared to be illegal. Full stop. Dr. Miss Kotoki, the Learned Standing Council, has submitted that there are standard procedures issued by the veterinary department, and to run a piggery business, comma, those procedures are required to be followed meticulously. Dr. P.K. Goswami, the Learned Council for the Responsibles, 8, 9, and 10, has submitted that as per instructions, comma, the firm is not presently operating. Full stop. For operating, full stop. Consequently, comma, there is no existing grievance from the side, existing grievance of the said responsibles, 8, 9, and 10. Para. Rival submissions. Para. The order dated 29/3/2023 appears to have been passed without giving a reasonable opportunity to the proprietor, and is based on certain complaints. Full stop. On that aspect of violation of the principles of natural justice, comma, the order does not appear to be sustainable in law. Full stop. Further, comma, though the jurisdiction of the Deputy Commissioner Nalbari has been questioned, comma, without going into that aspect of the matter, comma, the learned this court has considered the submissions advanced by the Learned Counsel for the petitioner, that so far as condition numbers 2, 3, and 4 are concerned, those have been fulfilled meticulously. Full stop. This court has also noted that there was an interim order passed in favor of the petitioner, which has been extended from time to time. In the this court has also taken into consideration the submission advanced on behalf of the respondent numbers 8, 9, and 10, that presently they do not have any grievance. Taking into account all the aforesaid factors and the factual backgrounds, comma, this court is of the opinion that the writ petition be disposed of with a direction that the petitioner be allowed to continue with the business. However, by following the standard procedure of maintaining such piggery farm without causing any nuisance in the locality. Full stop. This court further further directs that the condition numbers 2, 3, and 4 as contained in the order dated 29/3/2023 be continued to be followed by the petitioner for running the said business. Petition accordingly stands allowed in the manner indicated above.
Oblige, Lordship.
Item 24.
Good question. Item number. Oh. 24, what is this? Okay. Here for whom? Okay. And state is for the petitioners on call. On previous occasions also, there was on call, whereas 3 SS Roy, London State Council, and 3, your name? R. Gauhati. Land Council respondent 4 are present. Full stop. Even on previous occasions, there has been default on the part of the petitioners. Full stop. When this matter was taken up for consideration on 10/3/2026, noticing that there was no representation on behalf of the petitioners, the matter was adjourned till today in the interest of justice, with however an observation that in case of further default, appropriate orders would be passed. It clearly appears that the petitioners are not serious in pursuing this case. Full stop. Accordingly, the petition stands dismissed for non-prosecution. Interim order sitting. Interim order passed earlier stands vacated. Interim order sitting.
Item 25.
25, what is this?
But it's a contempt matter, my lord. The contempt petition filed against the order dated, my lord.
Notices issued,
Notice of your issues, my lord.
steps taken or not?
Steps taken, my lord.
When did you take steps?
After the notice of the issued, my lord, what has happened, my lord? After the notice were issued, steps were taken. They have also kept a hearing for kept a hearing to and asked us to bring some relevant documents, my lord. But again, they have delaying the matter, my lord.
But there is no concrete information with regard to the aspect whether they have been, whether the respondent
Because they have received information.
Not to appear with this.
WPC is written wrongly, my lord. It should be a contempt case, but the order is just 24/11/2025. On last order.
What happened on 24/11/2020, on 23/12?
My lord.
What had happened on 23/12/2025, 2 p.m.? You are
When the
directed to
hearing took
appear.
place, then again, the matter was kept for hearing again. My lord.
What is the order passed?
Nothing order has been passed.
No,
Nothing.
what is the order of this court?
or the order of this court, my lord, is on page number 29. The operative portion is at page number 34. They have not complied with the previous 3 orders of this Honorable High Court, my lord.
Let us see which order.
Paragraph number 18, my lord, 34 page.
Sumit Satawal.
However, in view of the aforesaid endorsement made by this learned.
He is the
additional-
present deputy commissioner of
Yeah.
Kamrup.
Yes, my lord.
Who's the deputy president? Swapnil Pal. That is what?
Sunit Satawan.
I think somebody else has come. You take instructions and you file an IA.
All right.
Okay. Your A.R. Barua,
A.R. Bora.
Heard Sri A.R. Barua, Learned Counsel for the petitioner, who has submitted that though a notice was issued directing appearance of the parties in alleged compliance, in purported compliance of the directions passed in WPC, of the purported compliance of the order dated 26/20/24 passed in WPC 1154 of 2021, no effective orders have been passed, and therefore the element of contempt is still there. Full stop, para.
Paragraph 18 of this. 18 of
Sri S.S. Roy, the learned state council, has however, who is present in the court, has however informed that there is a change in the incumbent who has been arrayed as respondent, as the sole respondent. Full stop, para. In view of the above, Sri Barua, the learned counsel for the petitioner, prays for and is granted 4 weeks' time to obtain instructions and file necessary IA for implement of the present incumbent. Pendency shall not be a bar to bring to bring the hearing fixed hearing for which notice was issued on 17/12/2025 to bring to a logical conclusion. Line to check to bring the proceeding initiated by notice dated sentence to a logical conclusion. Yes.
Item 20 for hearing.
Yes.
May I please, your lordship. My lord,
Your last name. Yes.
this,
Can we complete? How long will it take? What is the matter?
The matter is, my lord, regarding, my lord, an election of a cooperative society, my lord. That was, the earlier election was challenged before this honorable court, and this honorable.
Election we can complete, I think. How long will you take? Not much, I think. Yes, what is it?
My lord, this
Who are you?
I am. For
You're
the-
10 persons, 10
10
petitions.
persons, my lord.
2, 1 of 24. 10 petitioners. What do you want?
My lord, the some of the petitioners earlier, my lord, their nominations was cancelled, and challenging their nomination along with their voter list.
Nomination for what?
My lord, for the election of the board of directors.
Which cooperative society?
It is, my lord, Mongolpur Gwaliawar Cooperative Society in the district of Kachar.
Mongolpur?
Buali, B-O-W-A-L-I.
Okay, we'll get it. We'll get it.
Cooperative Society, my lord,
We'll
in the
get it.
district of Kachar, my lord.
Mongolpur Gwaliawar. Gwaliawar Cooperative Society.
In the district of Kachar.
So you are shareholders.
shareholders, my lord.
Oh,
And my lord, some of the petitioners nomination were, my lord, cancelled earlier, and their cancellation and the voter list used to be used in the election was challenged before the honorable court earlier, my lord.
few membership were cancelled.
Yes, nominations were cancelled.
Nominations for
For my lord, election of the board of directors.
BOD as well as
As well as
the voter list.
voter list. They had challenged the voter list, my lord.
In WPC
My lord,
395.
yes, my lord.
Along with the voter list.
Yes, my lord.
Then what happened?
This honorable court had directed to the appeal to the registrar, my lord, as per rule 27 of the Assam
Directed them to file an appeal.
appeal, my lord.
Which order?
My lord, page number 29, my lord.
25-1,
25-1, 23, my lord.
23.
Yes, my lord.
Court directed to file appeal.
Yes, my lord. Under rule 27, my lord, of the Assam Cooperative Societies election rules.
Yes.
So my, under that rule, the appeal should be filed after election within three days. So accordingly, election held, my lord, and the petitioners approved after election to the register of the Cooperative Society. Election was held 4/2/23, my lord.
4/2/23. Elections held
Held, my lord.
on the basis of the incorrect list.
Yes, my lord.
Nonetheless, you filed an appeal.
Appeal, my lord, yes.
When?
As per section on 7/2/23, my lord.
Appeal filed.
Yes, my lord.
But this court directed when, okay, 27-1, okay. You file appeal filed.
Yes, my
Then
lord.
what happened?
And my lord, accordingly, my lord, 13/4/28, disposed the appeal, passing an order, and the order, my lord, the appeal was, my lord, rejected. It is rejected, and against that, my lord, some petitioners had appeared, my lord.
Hmm?
Appeal was, my lord, rejected, my lord, on 13/4/23, my lord.
13/4/23. Then what happened?
When some of the petitioners again challenging that, my lord, appeared this honorable court.
Second time.
Yes, my lord.
Second petition filed.
Yes, my lord.
WPC
2684.
2684. Yes. What happened thereafter?
My lord, thereafter, my lord, the order of the approval was cancelled, my lord, with this honorable court, and the matter again remanded to the my lord registrar.
Approval order was interfered.
Yes, my lord. This honorable court interfered, and the matter again referred to the registrar, because that approval was given by the ARCS, my lord, and this honorable court held that it should be the registrar, my lord.
Yes.
Thereafter, my lord, the registrar, my lord, interfered with the approval, my lord. That it is in violation of the provisions of the Assam Cooperative Societies Act, my lord.
Yes.
Thereby, my lord, allowed the some of the petitioners nomination that they are eligible for to contest the election, my lord. And the operational part of this order, my lord, page number 56, that may be, my lord, looked into, my lord.
Yes. Then
There, my lord, the registrar held that they are eligible, and that the election should be held on correct voter list, my lord. That is page number 57. That is the observation, my lord.
yes.
And the next, my lord, the election was held without correction of the voter list, my lord, on 10/2/24.
Election held.
Election held, my lord. And the petitioners again challenged that election on 12/2/24 before the registrar, my lord. On the ground, my lord, though they have contested the election as per earlier order, that they were declared eligible, but my lord, the same
Now, what is your grievance?
grievance, my lord, there are, my lord, without correcting the voter list that it was held, and there are some different persons. I have also mentioned in my petition that they were expired already, but on behalf of them, vote were cast. Some, my lord, petitioners, shareholders were given double share cards to facilitate them to vote double, and some of the petitioners, they are not eligible. So there are about 120 cases, my lord, where it is found that during the pendency of the hearing before the registrar had directed the ARCS, my lord, to supply the copy of the marked copy where the shareholders appeared and cast their vote. Accordingly, my lord, we were supplied the copies of the attendance register, and after going through the attendance, we have found about 120 cases where there is manipulation of the signature of the thumb impression. I have categorically mentioned in my writ petition the specific membership
Yes,
numbers,
Mr.
all of
Talukdar.
them, my lord.
Order of the registrar.
Register, yes, my lord, this order is very clear. And 80, my lord.
But aren't you required to ensure that there is a correct voters list? The aspect of who files the nomination, that's one aspect.
Yes.
But the aspect of having a correct voters list, he alleges that persons who have passed away, their names are still there. Some other names are also there.
That is not correct, because your lordship will see, pursuant to the order which he has referred at page 56, my lord.
Yes.
There is the order of the register to correct the voter list.
Hmm.
And my lord, in terms
Has
of.
it been corrected or not?
Yes, your lordship will kindly see, my lord, after, my lord, the voter list is corrected, draft voter list is pasted.
Hmm.
My lord, and objections are invited. Complaints, my lord, are invited. Now, they have nowhere stated that, my lord, complaints, we have filed the complaint. After the draft voter list was prepared, we filed the complaint. Our objection complaint was not entertained. This is not their case, my lord. They have not stated. Now, coming and saying, my lord, voter list was not, my lord, corrected. That will not do, my lord. Prima facie, they have to satisfy that voter list was indeed not corrected, even after the order of the register. That is not their case. And if your lordship sees, my lord, page 88, this is a recent order of the register.
That is their case, that in spite of the registrar's direction to correct the voters list, no correction has actually taken place.
No, this is, my lord, for the first time, my lord, in the writ petition they have stated. But where are the materials to show that they have made the complaint? They have not annexed any complaint, my lord. That these are the dead voters, these are the anomalies. Please correct it. We have, because they have to file it before this, my lord, of society. This
What
is
do you
cast-
say, Mr. Kadir?
My
This
lord, I
aspect?
have specifically mentioned in my petition, my lord.
No,
that
no, what Mr. Talukdar is saying.
There was no notice, my lord. There was no notice of the.
What Mr. Talukdar is saying, that to have a matter before this court for adjudication, you have to have a grievance. Your grievance cannot be that voter list, in the voter list, there are names of persons who have died. Your grievance will be that you have approached them, in spite of your approach, they have not corrected.
Yes, my lord, there was no
Because
notice.
first you have to approach them, aren't you?
There was no
required to?
notice for objection, my lord. There, I specifically mentioned, my lord, in my petition, my lord. There is no draft electoral rule was, my lord, published in the office. my
But
lord.
on facts, Mr. Talukdar, why don't you look into that aspect, since it's before the court?
No, your lordship will kindly see, my lord.
You undertake an exercise
Yes.
to verify the voters list.
No, register has dealt with this, my lord. Small paragraph, page 88, my lord.
What
If your
has been
lordship
said?
sees page 88.
Please read.
Yes, the penultimate paragraph. Heard the petitioners and respondents. Peruse the documents submitted by both the parties. during the hearing, electoral roll and attendance register of shareholders, which was used for the AGM, was also perused. It was observed that during poll, most of the candidates were present and no complaint was lodged before the returning officer, and also signed in the declaration form at the commencement of the poll and at the end of the poll, as well as before declaration of the result sheet. They had signed it, my lord. They have endorsed it. Everything is correct. Moreover, allegations regarding the casting of voters by impersonation dead voters have not been established. Further, there was a huge difference between the winning candidates and losing candidates.
Mr. Kadir, there are disputes. In your projection of facts, they are disputing on record.
Yes.
My lord, as
And
per,
there is a division bench judgment. Recently, I can place the judgment saying that unless you show that the anomaly, if any, has materially affected the result, my lord, the AGM, which is, my lord, held, election which is held under the statute, it cannot be nullified. And this is not their case that the election is.
Where is that judgment?
I can give it, my lord. Recently, the division bench has passed the judgment. I can give it.
When we can have this on Tuesday then?
I
For
can give the
disposal?
number right now, my lord. I have the name, Badorpur Milk Cooperative Society. That is a case of Karimganj.
Today we will not have time.
my lord, let the matter may come next,
Huh?
next,
Division
next,
bench
I will also go through the.
Tuesday. But we'll dispose this.
That's, I'm appearing for the respondent number 10 to 20. This suppression of material facts is there, but serious material facts. They have contested the election, man. They have participated in the election. Accepting the Buddha list, my lord. It is not a case there.
It's not the case that nominations were cancelled, were not.
They have not, they have objected to the, my lord, they have accepted the nomination, they have accepted the Buddha list, they have participated in the election, and then once they lost, they came before the court saying that no, this Buddha
But
list.
how
is
are you
not correct.
maintaining your petition? Then you said that you are aggrieved.
I'll show.
You are aggrieved by.
Yes. And that fact was not, my lord, they have not mentioned in the repetition.
You said that your
participated
nominations
in
were
the election.
cancelled.
Yes, my lord, that was my lord.
But you had cancelled. You had participated in the voter.
That was allowed, my lord, in the register allowed, my lord. After allowing by the register, we have participated, my lord. But
Yes,
my lord,
They
but
participated in the election, accepting the nomination. And in the,
Okay, Tuesday.
my lord, they have not mentioned anything about their participation in the election, in the repetition, my lord, to suppress the facts. Serious suppression is there, my lord. They have not mentioned anything.
When was the election?
Election on 10 to
10 to what?
24, my lord.
10 to, and this repetition was instituted when? In 1st of June.
Yes.
my
They
lord, the
have not
rate,
mentioned anything.
rate petition, my lord, against the order of the registrar, my lord.
Yes.
The registrar, it is all, everything is mentioned, my lord.
But
And
don't you think that this is a relevant?
File before the register is also not annexed here with my lord.
it is there, my lord. My lord, for
But
a
Mr.
moment,
Kadir, don't you think that this is a relevant fact to have been disclosed?
Yes.
That you have participated in the election,
Yes.
though you are challenging the validity of the voters list.
Yes.
Once you participate, then
Accepting the Buddha list,
it amounts to an estoppel kind of a thing.
Yes. Acquiescence to ever, my lord.
my lord, my only one issue may be considered by this honorable court, my lord. The record, the register has perused, my lord. It is specifically, my lord, clear that there is, my lord, manipulation. There is everything, my lord, in the record, my lord.
See, that register's order is dated what?
Like, it is as per section rule 27, my
What
lord.
is
there
the
must be
date of the order?
My lord,
And
What is the date of the order?
10-5, my lord.
10/5,
10-5-24.
24.
24. And my lord, rule 27, my lord, clearly, my lord, says that there should be an inquiry, my lord. Inquiry, but the inquiry is not done, my lord. I have the copy
Okay,
of.
but we'll have it on Tuesday. then.
Okay.
Yes, my lord. That is the judgment passed by this honorable court saying that Rule 27 is mandatory. They have to file application within 3 days. Here is a case, election was held on 10, they filed the representation on 15th. So in violation of rules 27, this is also not maintainable, my lord. They cannot file the representation. That is decided by this honorable court that this period is mandatory. Rule 27.
We have filed in 12, my lord. 10 election and 12, my lord.
That fact, everything will.
Having accepted the voter list, why did you participate? How can you challenge now? You
Not
participated in accepting the voter list. Can you, having been defeated, can you turn around and say the
Yes.
voter list is defective? You have participated, you have accepted the voter list.
Okay, paucity of time may not permit the matter to be taken up today. List for admission, just for hearing or what? List for hearing Huh? So on 17, Tuesday.
Obligor.
This you can place on the next date.
Yes, ma'am.